years than I am, and you have vast experience in insolvency also, which is a law, although it is just 6, 7 years old. We've seen it develop a lot. So I'll keep it, as fluid as I can, and please feel free to stop me and ask questions so that the session can be more interactive, and we can share information and knowledge and make this an enriching experience. So broadly, we will cover these aspects today in today's session. We will start with one step before receipt of resolution plan, since that has a bearing. Let's begin with the stage at which the RP is required to make an invitation for EOI. The EOIs are received. That's where your scrutiny starts. I mean, role of the RP to scrutinize resolution applicants starts when you get the EOI. That is one stage before you get the process, before you get the plans. Plans are submitted. Then the next stage would be the most critical aspect of RP's role in resolution plan process. To place it before COC is to check whether the mandatory requirements of a resolution plan are met. This is, of course, an area which has undergone substantial change in law and understanding as well. From the early days of IBC between, say, 2016 to 18, when Supreme Court clarified, RPs believed their role was different, and naturally so. The code was not, clear on that aspect to that extent. Then we will look at, say, some recent amendments which have happened, and these are broad areas. Of course, in each of these heads, we have a multitude of tasks that the RP has to do. So we will begin, and please feel free to stop me wherever, and we can have a more interactive discussion. So as all of you are aware, the invitation to EOI is the stage at which, under the IBC, you are required to start the process for resolution formally. Until the date, which is now the 60th day after the recent amendment for invitation of expression of interest. Until this stage, RP is really performing a function of information gathering and taking charge of assets. Now, briefly to touch upon it, I mean, taking charge of assets could be very different in different processes. All of you have experienced both sides of it. There are cooperative corporate debtors and management. There are uncooperative corporate debtors and management. But in our experience, the most important task that the RP has to do in this stage, till EOI, is two things: claim verification and information gathering. These are the two things. Why? Because this will play a role in how you deal with resolution plans. All 90% of questions that will be raised on the RP post receipt of plans will be on claims, or will be on some information they will ask you regarding the corporate data. So these two exercises, I think, RP and RP's team will have to do throughout the 270, 330, whatever day. Information is something ongoing that you have to be on top of things. Now, the moment you
need to start valuation
also start valuation, absolutely.
Start valuation on 47th day.
Now, yes, sir, that's right.
And
sir.
constitute absolutely. COC, because dealing with the COC becomes very important. Most of the case, yes. Where small case, only one COC member, two COC member, their interaction, their action,
yes,
their cooperation. Sometimes we are finding smaller case, the COC member and the RP are at the totally different
wavelength. Yes, absolutely. Absolutely, that is a common issue that happens between RPs and COCs. And on that point, sir, I think the way the code envisages, RP is the captain of the ship. The owners of the ship are the COC.
Yes.
But the RP is the captain of the ship. The COC do not know how to steer the ship. The COC are not aware of how to steer the ship, nor do they have the powers in law to steer the ship. The power of steering the ship is only given to the RP, but ultimately RP is also answerable to somebody, and at some level that is the COC. This is, I think, the way both of your roles are defined, and at some point, yes, there could be an difference of opinion, and it has to be ironed out. IBC today is giving a lot of guidance on that aspect, sir. Thankfully, that aspect is developed substantially. So, sir, I was saying that publication of Form G and detailed invitation of expression of interest. You are all aware that under Regulation 36A, which was introduced a few years ago, the Insolvency and Bankruptcy Board of India has given a detailed process on what you should do for submission of publication of EOI. There is a Form G, which is a form and there is a more detailed document which we refer to as the detailed invitation for expression of interest. This is something, I mean, in our experience, we have seen that sometimes RPs will only issue the Form G. There are still RPs who are only issuing Form G and not issuing the detailed invitation for expression of interest. This, although, I mean, whether it is legal or not, that's a secondary question, we believe. But in terms of process, we feel it would be beneficial if you issue the detailed invitation for expression of interest, because that is like your first prospectus of what the corporate debtor is. It's like a snapshot of what the corporate debtor is. It will have a brief overview of corporate debtor, what sort of resolution that is being expected. It will also contain the eligibility criteria and other details that the resolution applicant has to meet, and the necessary forms that have to be filled. If this document is there, then it's sort of, that is the first stage where you filter out resolution applicants who will not seriously bid in the process. And that always helps, sir, because the number of plans you're dealing with as you get closer to submission, you want to deal with only those RAs who are serious bona fide contenders in the process. So this is two actions that the RP has to do at this stage: publish the Form G and also publish along with it the detailed expression of interest, which is typically hosted on a website that the RP will take control of the corporate debtor. Or if that is not possible, you can set up your own website. RP has those powers, and you can host the detailed expression of interest on the website. This is the most practical way this can be done. And Form G, of course, can be published, say, in the newspapers also, which is required as per IBC process. Now, another aspect, the first stage of scrutiny starts when you get the EOIs. Now, EOI will typically come as 4 documents plus details of eligibility. This is how we see it. Document number 1 that will be there when the EOI is submitted will be the EOI itself. That is the format in which the expression of interest is to be given. Then you will have along with it a confidentiality undertaking, which is again a legally mandatory requirement, because if you are sharing any information with any prospective resolution applicant, you are required to take a confidentiality undertaking as the resolution professional. The third document would be an undertaking under section 29A, which will also contain details which would be required by you to assess compliance with 29A, which is typically in the form of the list of connected persons. The fourth document would be another undertaking that essentially whatever is stated in the EOI and in the financial information that is submitted along with it is all true and correct, which is also something which is regulatorily required both under Regulation 36A and under Regulation 39. With these 4 documents, you have financial eligibility information. That is, of course, something that the Committee of Creditors will decide beforehand. They will advise you what sort of eligibility criteria they want to set for PRAs, whether that is basis net worth, whether that is basis assets under management, production capacity. This could vary vastly from corporate debtor to corporate debtor, depending on the operations. So at this stage is the first stage where scrutiny begins, because you have 2 actions which are there on the last point in the first section here, which is to create the provisional list and then create the final list. This determines who will actually be in the process going forward, because as you're all aware, Regulation 39 was amended, which now clearly says that the Committee of Creditors cannot consider a plan for approval submitted by a person who was not in the final list. So this act of creating the final list is a very crucial act. It is not a mechanical task where you just put somebody in the final list if everything is complete, and which is why this process of EOI submission is very hectic for RPs, as you would all know, because the timelines are very tight. You will all know in your Form G, the IBBI regulations say you will submit EOI, then within 3 days you will give RFRP and information memorandum, within 5 days you will give provisional list, and then again within 10 days you will submit final list. So in a matter of 3 weeks, you have gone from publication of EOI and receipt of EOI to issuing final list. So that is an important period, because you are weeding out the first set of non-compliant or non-bona fide and ineligible PRAs. That is the first stage. So here, from our practical experience, to everyone is that we often are faced, say there are two kinds of compliance which we see that we get queries from resolution professionals. The first is procedural compliance, whether, say, you may have set some procedure that something has to be signed here, something has to be notarized. There will be stamp paper requirement for the 29A undertaking. There will be stamp paper requirement for the confidentiality undertaking. If those procedural aspects are not complied with by any of the EOI applicants, can I put the EOI in the final list or not? Provisional list, we are all clear, unless there is some, say the EOI document itself is not submitted, you are not even clear who the applicant is, you will put everybody in the provisional list. You will say that law is giving you time to rectify these errors. You will assess and you will give them a detailed list. These are all the deficiencies that I feel in your EOI. Please rectify them. In our experience, the non-compliance of these procedural aspects can be overlooked to certain extent, and I will clarify why. Because ultimately there could be a party. I'll give an example. This is a very frequent situation that happens. There is a foreign party who has submitted an EOI. Stamp papers are not available for them readily unless they engage an Indian consultant who will purchase the stamp paper in their name. Notary will involve for them to apostille it, and then from apostille and through ministry certification they have to send it to you. That is the only formal process. This could take more time than the 10-day or 5-day period that you are giving. In these cases, we take a more practically sensible approach, that you confirm to us that you will send us a document addressing all procedural non-compliances, but I am subject to that. And after informing the committee of creditors, I am admitting these EOI applicants into the final list. Now,
so one more thing. Now that strategy for marketing needs to be prepared.
Yes.
That is the important
Yes, absolutely. You're very true. I will address
that. Has put up in the chat box.
Okay, I will address that, sir. Definitely. Okay. I am coming to that. At the RFRP stage also it is there. And I will also be covering it in more detail, say at the stage of key amendments. And since you have addressed that, I believe you had a session with Mr. Abhay Manudhane also in this. So at that stage, I believe when that session was held, this amendment was not there.
Not there. That was not there.
That is a key aspect. I mean, that might have a role in even HDIL's insolvency, which all of you are aware of, which is doing a large value project-wise insolvency. So we'll cover that, sir. So in terms of substantive non-compliance in the EOI, for example, there is insufficiency of information. If the 29A undertaking is not as per the format, if, say, eligibility criteria information is not provided, if the PRA is not able to satisfy that the PRA is eligible for whatever reason, not giving the documents, or the documents are not clear and you are not able to answer these questions, or say there are changes to the format of the confidentiality undertaking or 29A undertaking which change the meaning and spirit of the undertaking, then in these circumstances, our advice would be that you cannot enter this process, because this is not a negotiated process. We are not doing today. If any of you, all of you are familiar with tender bidding, if you go to tender bidding today, it is so pre-made that you go on the website and you click yes or no. Government does not even give you any avenue to negotiate. Earlier, 15 years ago, documents at least would be shared in physical form. Now it is all click wrap contract. You agree to the terms and conditions. IBC also to a large extent is like that. This format and process is prepared by RP in accordance with IBC in discussions with COC. So there is not much room for change here. But at the same time, practically, if there is some issue which is not affecting the spirit of the process, I think RPs are always amenable to look at that and continue with the process. With this, if you have the final list of PRAs, which you then, for the first time, you will publish the final list of PRAs to each other. So all PRAs know who are in the race. That is important as a stage, because this is a transparent process. There is no closed door bidding or negotiation that is happening. It's a transparent process. Yes, it's a confidential process, but it is transparent. Every PRA knows who the other PRA is and what they're up against. So there is no discussion that lenders can have with somebody who is not in this final list. That is the key of this. There is no outside discussion.
most of the time in EY, the parties miss the bus.
Yes.
And then they keep calling, yeah, give me 2 days, or I'll just send by email, and then subsequently the document will follow. Or sometimes there is some tragedy, One of the cases we had seen that the day the last date was that the Lata Mangeshkar expired and the office was closed and
absolutely
people could not submit, and then who is eligible to extend the date, whether RPs or whether only COC?
So this is an interesting question you ask, and I will just refer to something because IBBI
practical difficulties.
Yes, absolutely. So
a lot of cases, these all practical issues because people at large are not yet aware.
Yes.
So they come to know only 2 days, 3 days before the actually when the process comes and a EY date is ending, and they call and sometimes they don't get the number of the RP. They put a mail. They try to that notary. It's all time consuming in India also. It is not simple that today you decide and within 2 hours you can file the EY.
Right. So there are two views about this, and there are two views in this aspect, sir. One is the more tried and tested model, which is what I would also advise if I was advising the RP, which is that if a UI applicant comes after the last date, you please place it before the COC as the RP, and COC now has to extend the last date for UI. Although it is connected to the other aspect I was coming to. Supreme Court, in the case of Kalparaj Dharamshi, which was a judgment of the Supreme Court, there they said that in the commercial wisdom of the COC, they can also take an EOI applicant who has come after the date has passed. That naturally has to be read in the context of that case. But see, when Supreme Court says anything, it becomes law of the land. Even if Supreme Court makes a passing remark, even in law, it is called obiter. So even Supreme Court saying something in passing also has the force of law. It is not as strong as the ratio of the case, but it still has the force of law. The Insolvency Law Committee, in their report, which they published in March 2022, has in fact referred to this. They have said that Supreme Court has said this in one case, but we are seeing, and government's reports are telling us, that because of this EOI applicant submitting after last date, there is severe delay that is being caused. Because every time EOI applicant comes, there is discussion on whether we can take the EOI applicant. Sometimes COC says, we don't want to take this applicant, so let us not take the applicant. Applicant will go to court challenging, saying, I am also wanting to submit, these are my credentials, I can bring value maximization. Sometimes COC feels this person is a commercially strong party, so let us take him in. When they want to take him in, then they will extend the date and take the. So there is no consistency in the process. So which is why IBBI has suggested that you should not. In fact, they had recommended an amendment that even EOI date cannot be extended more than once. In fact, they made that amendment, sir, which you are aware of, which they said they can't make a change. But practically speaking, I mean, I will give you market practice, which all of you are aware of also. The way it is being read is that if you are only changing the date of submission and no other parameter, it does not amount to a change in the EOI. This is a practical reading that lenders have also required. I mean, how many processes do you know, sir, where EOI is extended only once and it has become successful? I mean, there are, I am sure there are, but they will be within 5%, maybe within lesser than 5% also. In 90% of the cases, EOI is extended at least 3 to 4 times. In the large insolvencies, we are seeing, sir, it is extended 12, 15 times the EOI is extended, and still there is not a satisfactory party which has come because there are complications involved. So these timelines won't work. So IBBI's intention, or rather the Insolvency Law Committee's intention, when they suggested that amendment to Regulation 36, was that you can only extend EOI submission date once and not after that. But the way they have worded the regulation, this interpretation is being taken, which is not tested yet. I mean, nobody has gone to court saying, how did you extend it 2 times? So when that happens, we will know whether that is what the courts feel. But going simply by how Supreme Court and NCLAT have been reading this law, personally, I don't see that they will read it in a way to say you can extend it only once. Because ultimately, code starts with preamble which does not refer liquidation. preamble only talks about insolvency resolution. It does not even refer to the word liquidation. It says liquidation is a part of insolvency resolution. If insolvency resolution fails, it will go to liquidation. So stress is on resolution. So Supreme Court has time and again said this is not like Companies Act where directly you will go to liquidation. There is nothing which happens in the process of winding up. Directly liquidation order is passed. This is not like that. So the way they have interpreted is if there is a chance that company can come back, let us look at it. Unless it is grossly unreasonable, arbitrary, we should always say try that option. That is the way they are reading it. So then information memorandum, I will just spend 2 minutes explaining why this aspect here is critical. We have done a lot of situations. Even yesterday, I was in the Supreme Court in a matter where this issue has come up in appeal after 4 years after plan approval, where one competing bidder is saying that I could not submit a resolution plan because you did not have audited financial statement provided in the information memorandum. Information memorandum says last 2 years audited financial, current year provisional financial. Most cases you will see where company is not a running concern, RP cannot audit the financials. Where will RP do it from? This is important because although regulation says RP shall provide financial statement, the section says Section 29 says RP will provide relevant information required by the resolution applicant to be able to prepare resolution plan. It explains relevant information. It uses the word financial position, not financial statement. So whatever you have with you to explain the financial position of the corporate debtor, that you will give. And same thing, Supreme Court in the judgment of EBIX has said that they have reproduced what Bankruptcy Law Reforms Committee had said, which is that RP will provide information as is reasonably practicable. You cannot create something that doesn't exist. But RP should be aware that RP has the power to appoint consultants. RP has the power to appoint a statutory auditor by following Companies Act process. RP can engage other consultants like forensic auditors, etc., forensic advisors to see what is there in the data room, what is there in the hard disk, in the SAP system, and try to create some provisional accounts at least on your basis. This exercise RP must do. The other thing RP must do is take steps against the management if they are not giving information. If you have done this, and if this is all you have as information, then you put that in the information memorandum with a noting saying these are the steps I have taken, but this is the information I have. Beyond this, I don't have, but I have taken these steps. If I get anything, I will update the information memorandum. This approach, Supreme Court says, is the correct approach. So that is something all RPs I would advise should follow, because tomorrow if some information is not there, like everybody has a different risk appetite. So some RAs may feel without this information, how will I bid? But there might be another RA who feels I don't need this information. It's okay, I'll reduce my price by 5 crores, but I will still bid. But the RA who does not get the information will say, but the law says you must give me information, so I will go litigate. So you can't stop anybody from litigating, but you can protect yourself, because the matter I was referring to yesterday, we succeeded. At all levels, we have succeeded. But you see, till appeal is pending, always there is that issue that you are incurring costs, plan is not getting implemented properly. So those issues are there, sir.
At times, question arises. We ask as a resolution plan bias advisor. He asks for tally data.
Yes.
That tally data. So most of the RP they have, but they don't give.
Right.
And sometimes earlier, now I think it is clear that we have to give a transaction audit report. We ask for even transaction audit report.
Correct.
So some RPs give, some RP says how you are not privy to that transaction audit report and so on. So what is the position as of now, or what is the practical?
No, so as I said, sir, I mean, they have to give you information. If RP takes a view that I have some information, but I will not give it, it's a very difficult position to justify for any resolution.
Tally data.
They're not able to, very difficult to justify how you cannot give tally data. You must give access to everything that you have.
But tally data is complete books of account, no?
Company's books of account. Complete, yes.
Complete books of account. From the bidder's perspective,
right?
Suppose I am bidding a company,
right?
And I want to invest money after seeing all the things. So basically, the asset, the records, These are the fundamental things
Correct.
I require to even assess that what kind of money I should
Right.
provide.
Right.
From this perspective, forget about the legal aspect, whether you should give or not give. If if the information is not there, suppose rightly said the financial statement, even some cases I found fixed asset register is not there. The plant and machinery he was saying this is available, but there is no register, there is no demarcation. If we ask it, show me the location where. So sir, it is not maintained, so we can't show this is the fixed asset register audited statement, so this is the statement. So this kind of situation, a true bidder may back out,
Right.
may not go for litigation. So suppose there is a company, there is nothing, and they are showing in the books why I should buy. But the litigation will happen when
Post.
later
Yeah.
if the applicant found that there was a data, fixed asset data, these were given to the XYZ applicant and these were not
Given
provided.
to me.
If it
Absolutely.
is not there for all.
Right.
There is no question of litigation. So this is from the business perspective I'm telling
No,
you.
you're right, sir. So, I mean, point is that is why I was saying that if you have something,
Yeah.
you must give it.
Yes, yes.
Uh,
We can't create it if the company doesn't have
Yes.
how we should create. If the creation
Cannot.
is there, is it possible? We will do it. Sometime what happened? The cost involved in the creation and recreation of the accounts is much higher than the asset is there. So
Right.
it is not practically feasible.
Right. So in some cases, we have seen RPs take an approach. If somebody, say for citing lack of information, if some party withdraws, says, I cannot participate because you don't have any information. One thing you can do is when you're extending the last date for plan submission, you keep inform that party also. Even if the party has withdrawn,
Yes.
you keep informing because that confidentiality undertaking doesn't fall away. And you can also continue to give access to data room, or when you upload something on data room, party will get a message saying this document has been uploaded. Courts have also considered all this positively in the sense that you as RP, you were still telling this person that, see, I've extended the last date. So if you still want to come, you can tell me. I am not stopping you because you had given EOI, I had put you in the final list. Later, you said you cannot participate. That was your decision. For your part, you continue to do these things and you please take all steps in your power to get that information so that you will be able to show objectively that yes, I agree this information is not there. Even you agree that this information may be relevant, objectively speaking. But how do we create it? I can only ask company or I engage some consultants. Now, consultants, they will do what is best possible. In some cases, they prepare the books with some disclaimers and caveats basis whatever information is there. They prepare it. In some cases, they are not able to prepare it before plan is submitted. So case to case, it will vary, sir. But as a guiding principle, I think you have some powers. Exhaust all those powers. Nobody should be able to ask you a question. Why did you not do this? I think that is the guiding factor of all things for RPs. Do everything in your power and please record everything because if you see your insolvency professional regulations, one of the things that it says in your code of conduct is clear communication. It's something very basic. We all understand it. But you will be surprised to see how many RPs are struggling to maintain clear communication with all stakeholders. Stakeholders are asking questions, clear answers are not coming. And later that snowballs into something else. 5 months down the line, some lawyer will look at it and they will ask, but why is this information not shared? COC will say, I have asked this question. This is what RP has given. But when you read it, the answer is not coming. So then already 5 months, 4 months have passed. These questions will be asked. Then IBBI proceedings, all these start because you're all experienced what happens. So these because complaints are being made in so many cases by lenders, by other stakeholders, especially by lenders. So because this is the I think that code of conduct, although it is like a guiding principle, it's very important. If you see it, it's very strictly worded. So I think that way, please exhaust all your remedies and record everything, sir. I think everything you please create a record so that in whatever way, I mean, that I will leave it to you whether you send email or in the next COC meeting, somewhere it is captured that these actions you have taken. Now, beyond this, I mean, I will keep updating you if anything comes out of these actions. So that can be the guiding principle. The last 2 points here, we are approaching, say, submission of resolution plan. Uh, a last date for resolution plan submission is fixed in the RFRP, and we will discuss that point on asset sale and RFRP in some time, sir. RFRP is prepared. It is typically seen as a COC document because it is largely a process driven document which COC wants on key things like how they will decide the plan, what will be the performance security, what is the earnest money deposit. These all aspects which are process wise but more commercially driven are mentioned in the RFRP. Yes, RFRP will also have a lot of compliance items. RFRP will say a lot of things that you have to give this document, that document, avoidance proceeds should go like this. But we will come to that when we are doing compliance. There will be two aspects to compliance. One is IBC and regulations compliance, another is RFRP compliance. They are both at a different footing because RFRP is a creation of statute which is created and voted by COC and decided. RFRP will give a last date for resolution plan submission. That can be extended. Of course, that date can be extended. If RFRP is modified, then of course IBBI regulations say you have to give again 30 days to submit a resolution plan. It will reset the clock. So typically the process followed is to not modify the RFRP. RP is given the task of preparing the first draft of the RFRP. So which is why it is important that your RFRP draft is a sound draft. It's a document which is very verbose, but with this amendment that you can't amend RFRP without resetting the clock. If tomorrow some issue is there, then fingers may be pointed at you. So why this provision was not there or there. But of course, at that having said, it's something you are doing with consultation with COC. Without COC's approval by voting, RFRP will not be published. Now there is a new regulation that was introduced. This was introduced last year, which was that the resolution plan, once it is submitted to you, it can be modified only once. No subsequent modification. Practically, we are all aware how we are navigating with it. We are working on, say, versions before it is finalized. But idea of this plan was also to, idea of this amendment by IBBI was also, say, Insolvency Law Committee had suggested that till the nth hour, the plan is sometimes drastically changing. We had a lot of large case experiences also, where 2 days before some new bidder comes and gives a completely different plan, or the plan is completely changed, value is substantially increased, which sort of unsettles the process because then the other person wants some more time to consider, can I meet the offer? Because everybody is seeing how much the other person is bidding. Naturally, that is the way the process is working, even though it is a closed door process. Unless you are doing a Swiss challenge method, which is also permitted under regulations, it will only be modified once. So you give a fixed date. Before that, you ensure all compliance is done, all observations are given to the RAs, and the plan is made compliant. And the plan is also made commercially as close as possible to what the COC wants. With this, at this stage, once you have received the plans, I think we'll come to one of the important aspects of what RP has to do under the IBC. I will also put up a more detailed document on, say, or you are all familiar with all the heads that you have to comply with. So broadly, we can look at it as payments, implementation and supervision, and certain other requirements that are there. So let's run through this list and then let's see what RP has to do. Payments, you are aware of this insolvency resolution process costs have to be paid in priority, completely paid. There is no discussion about that. If there are any finer questions on these points, I'm happy to take them. Payment of operational creditors, whichever is higher, either minimum liquidation value or certain times the plan will propose something greater of the two, whatever it is, has to be paid to operational creditors, has to be paid before any payment is made to any financial creditor. Third is dissenting financial creditors.
Now with this rainbow judgment,
Yes.
suppose financial, this sale tax liability or any
Yes.
liability is huge.
Yes.
And the COC will not agree. Suppose if I go by rainbow judgment, see if I have to pay 10 crore rupees to the financial, I have to within the priority. Because operational creditor to be paid priority to the financial creditor.
Right.
Then Financial creditor may not get anything, and the first state statutory liability will have to be clear.
That is there, sir. So Rainbow
is
is
there.
one of the things we were going to discuss. So since we are speaking, Rainbow is obviously the law as it stands
Today by Supreme Court.
by Supreme Court. It is the law of the land. There are two distinctions to Rainbow. One is that it is in the context of tax dues which are having a statutory provision of first charge.
Yes.
The statute will say that. In that case, it was the Sales Tax Act. Sales Tax Act has a provision which says we will have first charge over all assets of the corporate debtor till our dues are paid from the date when the demand is raised. If you, for example, look at it with GST also has a provision. But it says subject to what IBC says. We have first charge, but subject to the provisions of Insolvency Code. Now, GST has not been dealt with by Supreme Court, but Customs Act, which has identical provision, has been dealt with by Supreme Court. In Supreme Court, in respect of Customs Act, they have interpreted this provision saying subject to provisions of IBC, and they have said IBC will supersede. So you cannot say you have first charge because your act itself has been amended to say that it will be the first charge is subject to what IBC says. And IBC says you will not have first charge. IBC puts you at item number 6 in the waterfall. You are after everybody else. You are after, you are in other creditors, really, right? You don't even have a designated place because statutory creditors don't have a designated spot in that sense. You are same level as other operational creditors.
Customs is by which judgment?
I will just,
judgment.
there is a judgment, sir. I'll just tell you. I have the name of the judgment. It's a judgment of the Supreme Court by, it's not a very old judgment, sir.
You can.
I will just tell you the judgment's name, sir. So, what I was coming to was that therefore it will vary from case to case. But you're right. If say you have a sales tax due and there is a demand raised, then you don't have an option. So it will fall as secured operational creditor because reason is IBC has defined secured creditor in section 3, which is before corporate insolvency starts. Secured creditor is not defined as secured financial creditor. Secured creditor is a creditor whose dues are secured by a security interest created by corporate debtor over its assets, or say over some other assets that it owns.
Secured debt is not restricted to financial. It can be operational also.
It can be operational. Yes. So which is the distinction Supreme Court has drawn. Although in my respectful submission, it's not a very well-reasoned judgment, but it is the Supreme Court's decision today, unless it is, say, changed in a review petition. I am told that there is a review petition pending, but they have not issued notice on it yet. We saw in the case of Vidarbha also that Axis Bank filed review petition, but Supreme Court said, no, this is the correct law because of that word which says may as opposed to shall admit into insolvency. For Section 7, it says NCLT may admit the company into insolvency. So Supreme Court has said, this is what legislature has said. I will only interpret the law. This is my interpretation. So unless an amendment is made, maybe Sales Tax Act also will be amended to say subject to provisions of IBC, in which case Rainbow will be nullified. Diluted or nullified. So
judgment came recently.
Yes.
Like Vidarbha in the metro
Yes. After Vidarbha, several NCLAT judgments have come following Vidarbha, where they have not initiated CIRP for various reasons, because cash flows are there, money is coming, or say you have some decree which is being executed.
I think
Yesterday, day before, yes.
GTL infra withdrawn from
GTL infra.
So that has obviously, sir, created a stir, but these are all the ways the law is developing. I mean, it's tied to economic policy also, as Supreme Court is seen. So that issue is there.
Customs judgment of Supreme Court.
Yes.
Is related to Jyoti structure?
It is not Jyoti structure. So just give me a minute. My folder is just opening. I will just tell you. This is Sundaresh Bhatt versus CBDT.
Sundaresh Bhatt versus?
Central Board of Direct Taxes, Indirect Taxes.
The same ABG shipyard matter.
Yes, ABG shipyard. Sundaresh Bhatt. So dissenting financial creditors, in this also there was a judgment last year, I think early this year in JP Kensington. The law is clear that dissenting financial creditors have to be paid upfront. It does not use the word upfront. It says before other financial creditors. Now, if you recollect, earlier there was a stipulation of 30 days when the IBC was there initially. That 30 days was removed. The 30-day was removed for operational creditors and for dissenting financial. You just have to pay before you pay somebody else. So the question that came up, there were two questions that came up before the Supreme Court. One was in JP Kensington, they tried to give land instead of paying money. That Supreme Court said is not possible. You have to pay this person cash. Because what is the right of a dissenting financial creditor? If the dissenting financial creditor is a secured creditor, ideally that you are, by initiating resolution, you are taking away that person's right in liquidation to realize the security. Otherwise, I had security. But because all of you have decided that you will resolve, my right to go and take surface action is gone because asset is going to go to the new person. So you please compensate me. That compensation is tied to what value I could get in liquidation if I had sold the asset. But you please give it in cash now. You can't say you will give me land. I have to then go sell the land or give me securities or issue NCDs to me. That is not possible. Second was, when should I give this payment? Let us say a plan is proposing 3 year later payments will start. First 3 years, there are no payments. Moratorium on payments for 3 years. From 3 to 5 years, payments will start. A lot of resolution applicants have proposed a structure where they said, I will pay dissenting financial creditors 1 day before I pay the other creditors, but 3 years later. It is still in compliance with this text. So that there was in JP Kensington, Supreme Court had in fact decided this issue, but not as the main issue. But they had made an observation that the intention is not to force the dissenting creditors to stay attached to the resolution process. By doing this, you are making them attached to the resolution process. They have to wait for 3 years. They have to follow up to get their payments because they are not in the steering committee. They don't have any information. They are totally outside, but still they have not got their money. So Supreme Court said this you can't do. And this has again been clarified once again in Videocon's judgment, where NCLAT said this approach is not okay. You have to pay them now. Now means you have to pay them immediately after plan is approved. Which day you will pay, that is not decided. But you can't say that I will pay them after you take control of the company and you're running it and later, 3 years later. That you can do with the assenting creditors because they are approving your plan. So that is what they say on dissenting financial creditors, cash and should be paid upfront.
But then paid upfront means if I pay, say that 1 day, suppose I am paying over a period of say 656 installments.
Right, sir.
So they are proportionate installment. I should pay 1 day before, or that entire amount should be paid. That is also debated in sometimes in our studies.
But their entire liquidation
Suppose
value
I
has
have
to be paid
let's
upfront.
say 100 crore and 5 crore I have to pay to dissenting. I have said 100 crore I will pay in six months after 2 years.
Right.
His installment I have to pay entire 5 crore day one, or I can also break there into installment 1 day before that installment I am paying you. That is before that installment.
As per Supreme Court, you have to pay entire 5 crores.
5 crore day one.
That was the objection of IFCI and Bank of Baroda in Videocon's judgment because they were being issued NCDs.
NCDs.
So the argument was my NCD will mature after 5 years. I am not waiting for 5 years. I have said I don't want anything to do with this process. I have rejected the plan. Please allow me to, in the words of the Supreme Court, they say you should allow the dissenting financial creditors to disembark from the journey and not continue in this journey. Their journey has ended with this company. They want to leave. So whatever is required as per law for them to leave is to pay liquidation value. Please pay that so that they can leave and then you can continue your plan, how you want to implement monitoring committee, steering committee.
Question is dissenting arises. Sometimes the plan is approved below liquidation value.
Yes.
So 100
Yes.
crore is the liquidation value and
Yes.
plan at 80 crore is approved.
Correct.
Now the person who is dissenting, if they are paid as per the liquidation value, then it is incentive for them to
No, sir. In those cases, say famously in that Maharashtra seamless case, it was approved. It was approved. Yes.
COC can approve the plan
Correct.
which is below liquidation value
Yes.
because liquidation value is a guiding factor, not a.
Yes.
So now in this case, the dissenting financial creditor to be paid as per 100 crore or 80 crore?
No, it will be as per 80 crores, sir, whatever is on the table. I mean, where will the money come from?
But then that provision is not
It's
clear.
not there. It's not there. Unfortunately, Supreme Court was only dealing with whether on the legality of whether you can submit below liquidation value. But practically, this is how it is being done. I mean, this is not so common in most insolvencies, but in say real estate insolvency, it is not uncommon. When they are doing project-wise insolvency, there will at least be one or two projects where liquidation value will be higher than plan value.
Liquidation value will be higher than plan value.
Yeah. So in those cases, sir, the dissenting creditor will simply be paid prorated liquidation value based on what is on the table. It will be prorated.
Then one more question, and while preparing a plan, say I am preparing a plan for 100 crore. Today I don't know whether I am providing, say, everything will consent. So I am providing, say, I will pay after 2 years, after 3 years, 4 years, whatever my understanding is. All of a sudden, when the plan goes for voting, and then we come to know that there are 30% who have dissented. So then entire my financial calculation goes for a toss again. So if the plan is submitted, it is approved, then I have written that I will pay a dissenting financial creditor prior to that. But reading this Kingston judgment, then how I will have to rebalance the entire plan, or how it will be? Or the other financial creditor will go, if I pay this 30% creditor day one, then 70%, the other side will not be able to pay anything because the lion's share has gone to the dissenting.
No, but has your plan gotten approved or is rejected?
It's approved. 30% dissented, 70% approved.
Okay, but your calculation of what is dissenting. Sir,
That's
but
all practical question when we.
yeah, but unfortunately, Mr. Navandar, the way the process is designed, earlier liquidation value was being disclosed to RAs. You're
Yes.
aware. Then they stopped that because precisely of this issue.
Yes.
You are looking at it only to calculate dissenting, but once the value is known, everybody is bidding close to it. I mean, it's another matter that even today it's an open secret. But that's another matter. But practically speaking, you as an RA are giving a formula-based confirmation in your plan. And as RP, you have to see whether plan is complete. That is what Supreme Court says. Completeness over compliance. Your job is to first see if it is complete, meaning if there are 10 items which regulation and section prescribes, something should be said in the plan for each of the 10. Then you will say dissenting creditor is missing. There is no provision only. Then you can't, you have to tell the COC that he doesn't even talk about dissenting. So it's not a question of non-compliance. It's an incomplete plan. Please don't vote on this. That is my view. Then if COC votes, it's their prerogative. So in that context, the resolution applicant will simply say that I will pay liquidation value to dissenting financial creditors.
On priority.
On priority. Because RA cannot say anything other than that. There is no other way you can word that sentence. As soon as you say that, if your calculation has gone wrong, there is no option. Because today, the way the law is, you can't withdraw from the plan. You can. Your bank guarantee will get forfeited. Your performance security will be forfeited. Lenders can also initiate say proceedings against you for withdrawing or criminal proceedings.
Not eligible for subsequent application. No, that is if the plan gets approved.
Yes.
Otherwise,
I mean, in certain cases, if there was an unsuccessful RA, lenders may say, okay, what is the point of doing this? Let us approve this person's plan. Let us put it to revoting. If that is possible, if the time is there, you can do that. But yes, you cannot withdraw. So if you are advising resolution applicant, that is a risk that you have to calculate and take in your costing, because you can't withdraw the plan. Your money will be stuck. Your performance security can get forfeited. There can also be exposure against you, like we have seen. Those are very different cases. Liberty and all there was willful non-compliance, but it's possible. The law provides that if you knowingly submitted plan and you ran the whole process and then you suddenly say, no, I have changed my mind. You can't do that. You can't change your mind.
only thing is that because somebody dissent, my entire financial calculation goes for the toss, and then to pay them on a priority, and pay other financial creditor whatever I have written, I will have to pay them.
Yes.
And to pay them and a priority becomes a very difficult situation.
You're right, sir. I mean, there are cases. This is exactly the calculation which RAs face, and which is why they say we will pay in deferred fashion. But courts are not agreeing with that.
Yes.
Courts are saying, in fact, if you read J.P. Kensington's judgment in the Supreme Court, they say you can also give the dissenting creditor theoretically the option of going and selling their security.
But how can that is possible?
That's not practically not possible, which is what Supreme Court says. Therefore, it is almost like giving them the option of going and selling their security. Because they can't, because it will disrupt the insolvency process, you must give them the money right away.
So that application was by the dissenting financial creditor in JK.
Sir, yes, it was, sir. ICICI Bank had dissented. ICICI Bank were being given land, actually. There, they had a problem. They said, you have to give me cash. You can't give me land. But NBCC's resolution plan, they said, we will not give cash. This land is worth XYZ as per books of company. We will give you the land. Land is more than liquidation value. I'm giving you extra money. But ICICI said, I don't want the land. I want cash. So Supreme Court said, you can't give. No, there is no provision under IBC to say you will pay in kind. Because they said the moment you say this, hold on. They say that the moment you say this, tomorrow somebody will say, I'll issue an instrument to dissenting financial creditors. So the idea is that you must give cold cash. That is the idea for dissenting financial creditors.
One more on this related, this operational creditor, they have to be paid in, earlier the law was within 1 month. Now
Yes.
it is again priority.
Yes.
Now there are two types of payment. One is based on the liquidation value or another is on the plan amount. Suppose on the liquidation value, their eligibility is 0. And as per plan also, if it is 0, but out of, as a justice or just to be fair to everybody, we provide some small amount so that everybody is taken care, every stakeholder is addressed. That also lands into priority, or that is which I'm paying over and above
Yes.
plan amount, I'm paying over and above the liquidation value.
Right.
But that also is hit by the priority or not hit by priority.
Sir, I mean, it is arguable, but courts are taking the view because the regulation is worded in a way that that sentence which is coming that it has to be paid in priority is coming after the two options.
After the?
After the two options. Two option is greater of liquidation value due or whatever the plan prescribes,
Yes.
whichever is higher.
Yeah.
If both is 0, if liquidation value is 0, your plan is giving 100 rupees. The sentence which says that this should be paid in priority to other creditors is coming after the two options.
Yes.
So the way the court is also reading it is that please give them their money first and then you do everything else. Because you are going to give them some insignificant amount compared to your larger resolution. And for resolution applicants to argue against operational creditors in court is quite challenging because courts know that they are anyway not getting anything. Most cases. Operational creditors are not getting anything. Nowadays, we are seeing plans where some payment is being made, but it's not significant. It's
just said paid to so that they don't.
So that some business continues because you want to engage with same suppliers. Maybe you want to engage with them in the future. So at say 80-90% haircut, you are giving them some amount usually. That's the 12 to 15% is what we are seeing usually for operational creditors. So that is the positions.
So there also, whatever we have to pay, we have to pay it up priority.
You will have to pay it upfront. So other than, in short, these mandatory payments, what you see, have to be paid upfront. That is what the law is saying. Costs of insolvency resolution, operational creditors and dissenting financial creditors. You will have to pay them upfront.
Now, in the case of dissenting financial creditor, if he has a security more than his amount, so he is to be paid accordingly or proportionately?
Sir, there is no answer to this yet today because that matter is with Supreme Court. The question you are essentially asking is whether the priority of security is to be taken into account when you are calculating liquidation value. That is what you are asking.
Means suppose I have a plot of land as a security in a residence, a real estate project. I have a land secured to me, and which is about 100 crore, and I have only 50 crore liability.
Right.
So, and if you average out then I will get only 10 crore.
So your liability is what will be paid. I mean, so there is no doubt about that. Let us say you have 500 crore property. Your liability is only 300 crores.
Yes.
Whether you sell it in an IBC, you sell it in liquidation, you do surfacing, you can't keep the 500 crores. You can only
No,
keep
I can keep 300,
only
but
300.
on an average, if the secure total my share is only 20%.
Yes.
So I will get 20%, or I will also have to go bear the haircut, or other I will get my full 100.
So this is the point that is being agitated by some creditors. There are two ways of looking at this. One is IBC says that liquidation value due as calculated if the company has gone into liquidation and you are under a section 53 sale, not 52.
Yes.
53 does not have, it has two categories. 53 has one category which is secured creditor, period. There is another category who is secured creditor who has relinquished security interest in 52 and then come as an unsecured creditor for the balance.
Yes.
So one way of looking at it is that you are talking about resolution. There is no you going alone and realizing your asset. It is all asset of company. There is a resolution plan. You only have voting share. If your voting share in COC is, say, maybe there are a lot of cases where you have exclusive security, but your overall share in the financial debt is only 4-5%.
Yes.
Then the way CIRP works is that you don't have the say in this matter.
Yes.
The creditors who have given more money but don't have exclusive security, they have pari passu security, but they will have the say because IBC works on voting share. So resolution works on voting share, which is tied to not exclusive security but tied to amount of debt.
Yes.
So that view is that therefore whether you have exclusive pari passu, it is not counted. All of you are in one category. You are secured financial creditor. You are at the top along with workmen. Inter say between you, your security is better quality, your security is more, that can't be decided. But at the same time, that discretion is given to COC when they are deciding distribution and resolution plan. Section 30 subsection 4 says, how do you distribute the 500 rupees that is coming from the RA? Can I distribute it pro rata to everybody? So COC in SR Steel, as you all know, this distinction came out to
Yes.
deal with SR Steel.
They gave less to
Standard Chartered Bank. So I was advising Standard Chartered Bank at that point of time. So our argument was that we have Standard Chartered Bank had the fourth highest debt. They had about 4,000 crores, which was much more than a lot of the other lenders. After Edelweiss, SBI, and one other lender, it was Standard Chartered Bank. But Standard Chartered Bank was not a lender to SR Steel. Standard Chartered Bank had a guarantee from SR Steel. They were a lender to a US subsidiary of SR Steel, and they had security in the US over some coal mines. They had no security in SR Steel. So the lenders said, this person is an unsecured creditor. But the way RP looked at the claim form, and at that point of time, it was not called claim form, it was called proof of claim. And that also changed later. So RP said proof of claim I cannot put them as unsecured because they have given me security documents that they have security over coal mines in the US. It does not say secured creditor having security over interest of corporate debtor. That is what RP said. RP said, I can't take this view. They challenged it. They went to NCLT. NCLT said, no, what RP has done is right. You proceed with the resolution. So they proceeded with resolution. But when distribution came, they said, we will not give the same money to Standard Chartered. But their logic was, I have given money to SR Steel. This steel plant is standing because I have funded this money. Standard Chartered Bank has not given a single paisa to SR Steel. They have given money to some other company. When that company goes into insolvency, they will get money. I won't get money in that company. So why should they be at the same footing as me? So they made a distinction of project assets and non-project, project lenders and non-project lenders. They put Standard Chartered as non-project lenders because they could not put them as unsecured lender. But today, if the same claim is submitted, RP will not verify Standard Chartered as a secured creditor. RP will say you're an unsecured creditor. You have no security interest over the assets of the corporate debt. So therefore, if you see all distribution mechanism, the day plan is voted, we'll have 1% for secured creditors, 1% for unsecured creditors. It will not be the same. And IBC allows them because logic is, sir, essentially, I mean, it is commercial logic. if you have given money and using that money, corporate debtor has created that company, then those lenders feel I should have the first right. Somebody who is a third party who has come with security in a subsidiary or something like that, he has only guarantee. That person can't be at the same footing as me.
Problem here, Vishnuji, is that commercial knowledge is good or commercial logic is good. The problem is that once it's come to the NCLT to challenge that logic,
Yes.
it nowhere stands.
Yes.
And everybody interprets in their own way.
You're right.
What you said here that it is a priority payment, priority you said upfront.
Yeah.
But there is nothing defined upfront.
Nothing is defined.
And in fact, if you recollect in 2018, this was changed also.
Yes, 30 days.
It has to be paid first, all the
Correct.
descending, then the ascending will be.
Yes, sir.
Now the change to priority. Now
Right.
the priority is not defined.
It's not defined. So thankfully, at least with this, Supreme Court has come out with some judgment, which is saying that you have to pay it upfront. In JP Kensington, they have said
That is for the cash.
that is for the, you're right. So, but in JP Kensington, they've also made an observation as an arbiter that it has to be, you have to allow them to disembark from the process the moment the plan is approved. That logic in Videocon, NCLAT has used it, and NCLAT has agreed with, because Bank of Baroda and IFCI were given debentures. Bank of Maharashtra, I'm sorry. And IFCI were given debentures. They said you can't give debentures.
There also, that logic was not there.
No, it was, sir. Both questions are answered. You're right.
It was not answered. Sir, because what we have read that this answer for the priority payment, whether it is upfront.
So
That was not answered.
there are two, you're in the sense that there are two findings there. One is that you can't pay cash.
That is
They have also upheld the argument that even if otherwise, the money is coming to them only after 5 years. That also NCLAT said you can't. Both aspects they have answered. But it is still up for argument because that judgment has also gone to Supreme Court. Vedanta is reading it. Vedanta's plan is approved. So my colleagues are advising Vedanta in that matter. So they are interpreting it the way you are saying. They are interpreting it as there's nothing which says I have to pay them now. I will pay them tomorrow. But the overwhelming number of cases in jurisprudence is that it is now, because Supreme Court has said so in JP Kensington. But now if Supreme Court takes a different view again this time, because you see JP Kensington, there are two paragraphs there, very clearly that is the intention. I mean, there is no other way you can read it. I agree with you that the question as to whether it should be paid upfront or not was not the question in that case. But even if Supreme Court says something which is not about the question, it is the law. And today, the way we are all interpreting it is that if you ask me whether you can submit delayed, I will say the law is not. But if you still want to take a chance, that's up to you. Supreme Court can always take a different view.
Because what happened in Ahmed Metalik, they have defined one similarly situated creditors.
Right.
So if similarly situated creditors are there you can have at least one line of action or one
Right.
line of distribution. But if it is not, then what you're saying is right, okay, you can give them something like that. But if similarly situated creditors are there and one become a dissent,
Right.
and they say you give me upfront, and that is also a liquidation value,
Right.
then it's become a difficult for other people because they will be getting after deferred payment, which is less than what less than what the other person who's dissenting has got now.
So this argument was made, sir.
Doesn't fit anywhere.
No, but this argument was made, but I don't know if you are saying that the NPV of the assenting lenders is lower than the dissenting.
Absolutely right.
That's a strange sort of plan. In fact, if you please see JP Kensington, I will send that judgment to you also with the paragraphs. This was the argument that was made by NBCC. But Supreme Court shot it down saying, you please show me from plans that are approved in how many cases this can arise. This is a very obtuse sort of case. In 99% of the case, the dissenting creditors will be paid far lesser than the assenting creditors. Even if you
talking about similarly situated creditors, where pari passu charge there of the creditors.
But again, then it comes to what Mr. Lavandar was asking: is charge important when you are getting liquidation value? Is your charge position, is that because you're all similarly situated, you all have pari passu charge, right? So in that sense, you are saying because that plan is a plan which says I will get payment after 7 years.
Yeah, he's not agreeing.
He's not
a percentage is only 5%. Why should I stick with the 95%?
So that's it. Then if the law becomes this, what we are discussing today, if finally, let's say Videocon may be a case where it is decided, it may also not be, because बहुत सारी चीज सुप्रीम कोर्ट जाता है, withdraw करके वापस आता है, तो law settle नहीं करते. अभी DHFL के matter में भी वो that whole Niyati healthcare avoidance transaction, we were all waiting that Supreme Court will decide it, वो ऊपर जाके withdraw करके आ गए. So वो भी हो सकता है. अगर वो decide हो गया, if the Supreme Court says clearly that you have to pay them upfront, then that means commercially these sort of plans will not get approved. COC will stop allowing people to give 7-year plans. Give me a 3-year plan, give me a 5-year plan, depending on the liquidation value. But I can't agree to give, I'll not get any NPV. Because there is no way to control who will ascend, who will descend. In cases where there is JLM, okay. But there will always be one person outside the JLM who will also be having 10%, 14%.
JLM also, they are not bound in IBC. It is only a ICA which is.
No, they are not bound, sir. But I mean, rarely do we see, that is a very rare case where JLM में सबने हाँ बोल दिया, then they come and say, that's
private banks.
होता है, sir. Yeah, but say JLM and core committees, this is the best. I mean, there is no hard and fast rule because ultimately, only when you click on the voting button will you decide, right? So it has to be seen.
Last, we don't know, na? And there is actually in IBC, the COC members have nothing to say when they dissent. Yeah, some members dissent just for the sake of dissenting. And when we ask them, they say, we have higher authorities, we have dissented. That's the only answer we get.
Right.
But there is no reason why they have dissented or why they have voted against. And that provision should also, COC should be made accountable. If you are not approving any resolution, then you should give at least 2-line reason why you are not approving that resolution.
Right.
Only in the resolution plan they are supposed to give, I think, why they are not. But in normal resolution, suppose I put a cost, say 2 lakhs rupees this cost, they just dissent, don't vote in favor, but they don't have any. Sometimes also something is mandatory requirement. Say valuation is mandatory. How can they get?
That difficulty is there.
Yeah.
Ultimately,
In one bank is how can we pay this money? हमारे तो 5-5% रहेगा तो तभी कुछ नहीं आते.
so that is there. That is there. Now, अभी तो that regulation 31A has come where cost tax भी देना पड़ेगा सबको 1%, 0.25%.
उसमें problem नहीं है.
But वो भी तो CRP cost से ही तो जाएगा, sir.
You have to pay. No problem. Somebody asks you, you may do it.
हाँ,
Then there is a problem.
You are right. There's a difference.
So आरपी का जो इंसेंटिव डाला है वो मे लिखा है.
जी जी.
पीपीए का लिखा है वो शेयर लिखा है. वहां पे जो लेंडर से यार मे है तो हम क्यों करें?
That mentality also.
It's a see जो लॉ बना रहा है वो उन्होंने लिखा है. So it's not a mentality of a lender. It's a mentality of the law is becoming. It could have become shell also.
Right.
When we say 1st October onwards, it will be shell will be paid to the regulator.
Right.
And it could have been shell for the RPs also. What was making the
So the second section, management, implementation and supervision, this is mostly, say from the point of view of completeness. Yeah, please.
I don't know. I think I might have missed. So either here the this mandatory payments now is becoming a talk of town with regard to Jet Airways case with the PM.
Right.
So where we stand in that, because that is also becoming now mandatory payment, whether you are here, whether you are in the section or anywhere.
Yeah, so I mean the position that NCLAT has at least taken now in Jet Airways, which is today.
And that is also after approval of plan, not
That, right, because see, after approval of plan, but वो application pending था sir. NCLT में भी application pending था, the issue of how much they have to be paid, that was pending because they filed a fresh application because their case was that only after plan is approved, when RP sends me that email with the formula of payment, only then I get to know how much I'm being paid. That is their case.
So that was the case.
That was their case. So gratuity, they are saying you have to pay the whole thing.
But somebody will terminate that. Nobody is terminated as of now, right?
Nobody
It's not terminated those employees. They are continuing.
because resolution there is no termination. Only in the liquidation there is a
Yes.
termination that
So as and when they will terminate or retire, they will get a gratuity. How the gratuity is paid?
But those,
gratuity.
a large sum of at least the claimants there, they are
all
terminated.
like
They are all terminated.
white collar this thing.
हाँ, but gratuity तो सबको ही लगता है, sir. I mean, yeah, gratuity is for everybody. And Jet Airways had a large, quite a generous gratuity policy. It's 10%, and I think they had more than 10%. Minimum is 10%. They had much more than that. And gratuity has no upper ceiling unless you make it. See, the issue with
Yeah, that is
gratuity.
only for a tax part. But
Right.
selling is
So,
the loan selling is only for tax.
gratuity, if it's a running concern which is not in distress for many years, Jet Airways was in distress for many years before it collapsed. Then you have insurance, you have a tax structure, you have a trust mechanism, and it will it is taken care of. Now all of that falls apart when the gratuity liability mounts. But this I can verify this if you are saying that wo sare terminate nahi hue the, because from what I have read in the order, it is not saying that all the applicants were all current employees. A lot of them are terminated because the termination information is also given in the order. So they are saying that they have now ordered 265 crores as liability to be paid. Large chunk of that is pertaining to gratuity because gratuity can't be calculated for 24 months. Gratuity is something that you are owed as a sum which is accruing. So practically you cannot cut it for 24 months. Then you will only get a very, very minuscule amount of it.
On the contrary, my view, the day it is arisen, it is calculated, but it is arisen on the date of termination. So it is within 24 months. Now, how can you say that it is accrual? Say, I joined a company today 10 years.
So
My
PF at least. There
it
is
is
a
accrual basis or on when it is due basis?
No, so at least PF is.
PF is to all liabilities, that is the priority under the constitution.
So gratuity and PF are at the same level. I mean, so far
PF
as.
is much stronger, I think. I don't know.
मतलब उसका भी 2 साल के लगेगा ना वो.
Sir, but-
PF दो
but
साल का नहीं लगेगा.
gratuity-
Under the constitution only that is protected.
Sir, but PF and gratuity, so far as industrial disputes law is concerned, your labor code, there is not a significant difference. अगर आप रनिंग कंसर्न में देखोगे, आज आप ग्रेचुटी नहीं पे करो तो ग्रेचुटी कमिश्नर विल कम टू योर ऑफिस, पीएफ कमिश्नर आल्सो विल कम, बट पॉइंट इज
PF
दे
commissioner will have right
He
to
has-
arrest you.
so gratuity commissioner also has right to arrest you. PF commissioner only has charge over your assets, which is not there in gratuity. So that charging provision is not there, but you have imprisonment liability even if you don't pay gratuity. Gratuity is not a, it is ex gratia, but the ex gratia में 10% is mandatory. उसके ऊपर आपको जो देना है that is up to you. But that it is not legal. Otherwise nobody will pay it, sir. अगर पूरा optional कर दोगे तो कौन देगा gratuity इंडिया में? Nobody will give. Like, and it's only for employees, right? Only workmen and employees get gratuity.
Voluntary उसको लेना हो.
Sir, right. So, but issue is that the definition of workmen and all in India is very fluid. Worker is a very fluid definition. A lot of people can come into that interpretation. Now, RP, as RP, you can't go into that interpretation that this person is a worker, this person is not worker. You will admit the claim. You don't want to get into that. Supreme Court has said you cannot decide anything. You are only collating claims. They have used the word collating. We all say RP has admitted. Admission word hai hi nahi IBC mein for RP. It is collation and verification of claim. Admitting the claim is something we use colloquially. Supreme Court is saying you collate and you verify.
But the classification is also there, no? Workmen, financial creditor. I can't classify financial creditors into operational creditors.
Correct.
So, likewise, if the claim is coming of person
Who is employee and not
who
worker.
is employee, workmen or not there.
But
So, prima facie, I have to check. No?
you have to check. But I am saying there will be lot of cases like Jet Airways, like what he is saying. Lot of them are white collar employees, but they were being paid PF and gratuity in the same position as a worker. So then that was the company's decision. Today, how as RP can you change all that? Because for so many years they got, it will open a lot of disputes. Unless, of course, that is the position in discussion with COC you are taking. Because
You will not decide this. Na.
they will not decide. So,
COC only says कि हमको क्या मिलना बताओ बाकी.
हाँ,
बाकी कुछ
so
नहीं.
when you go to any resolution plan approval, sir, they ask you 2-3 things. OC को कितना दे रहे हो? If you are giving 0, please tell us if you can give something. Worker को कितना दे रहे हो? If it is very less, you please tell us if you can give something better to worker, some extra. They are always trying to be populist, the judges. They are trying to see that because press में उनका भी आता है कि so and so approved resolution plan with 95% haircut. So and so approved resolution plan. आज बताइए last 2 years में 50% haircut में कौन सा plan approve हुआ है? कोई भी नहीं हुआ. After the
Means only 10-12% people get or 20%.
So after the first 12, 14, 20 companies which went into insolvency, which had healthy assets, and which is why RBI also realized that early on, that we will send these 12 into insolvency ourselves before the asset quality further deteriorates. Those companies got good recovery, 70%, 65%, 80%. SR Steel and all got very good recovery. But after that, today you have large companies with lot of debt but no asset quality. So you are not getting that recovery. So
Why it is happening, one thing. See, I have one steel company which was closed in 2012. So financial institution is calculating the interest at 17-18%. Why the haircut is so? Say from the date of closure, if the unit is closed in 8 years, they are with that 17-18%. If debt goes to 4 times normally, if 100 crore debt is there, today is a 400 crore. Second side, if you consider the steel plant which is closed, that time it was 100 crore. Today it is what 20 crore because now it's not operational and it is all rusted. Now that technological, financial wise, everything, the labor has left. Even today, that plant which is 100 ton per day manufacturing capacity, today any steel pipe will say below 1000 ton it is not viable. So there it will go only in the scrap. And if you consider now that scrap value 25 crore with a 1000 crore financial debt, it's hardly 2%, 3%. If you say 97% haircut, but this is a situation.
Right. No, you're right. So time is of the essence.
You take a Mercedes car and don't use it for 8 years. It will give your debt for 50 lakhs will become 400 crores. Right. And the car of that value of that car will be 10 lakhs rupees. Right. Now, if you calculate arithmetically the haircut, it may look at 90% haircut.
Right. No, sir, I think, see, the aspect of how quickly you can do the process.
Yes.
As RP, you can always set the timelines and you can endeavor to achieve it. But ultimately, decision is of lenders. If there are people coming into the process, lenders want to open it up again. It is not in your prerogative to say no, because it's a process. Ultimately, they are the owners of the ship, as I was alluding. You are only the captain. You can only guide them that if you do this, these will be the consequences. But lenders are also today very well aware of this process. They are taking certain decisions because of larger considerations involved. We are all aware what's going on in so many matters. There are criminal proceedings involved. So they all have a process that they want to follow to show that we have tried everything to extract the best value. But you are right, in certain cases, the value deteriorates because of these sort of practices. It's a balancing act that will have to be done.
In the mandatory payments and the verification by the RP. So what we should do for the PF and post gratuity also?
PF and gratuity.
So now, I mean,
assuming the claim is including everything of PF.
PF is 24 months.
7Q, 14 section and everything of
of the PF.
So the NCLEX and NCLT judgment and the Assam T also.
Right.
They say you have to pay full.
Right.
Pay full everything first.
Right.
So whether it fits into that, mandatory.
There is a lot of
RP, what we should do
with PF, especially. There is a lot of different position in law, because for gratuity, they have NCLAT is very clear in this jet-based judgment that you pay the whole thing. But for PF, if you see, largely it is calculated only for 24 months in Jet Airways also. But you're right, there are cases where even in NCLT Mumbai, they have said you pay the whole PF, entire PF.
Recently,
precision first done, na?
Assam T is also.
Where the claim was, I think, 2 crores somewhere. They have paid 50% of that.
Yes.
Again, I get you pay full.
So I
don't know. So in Jet Airways, they have calculated PF for 24 months.
24 months.
No, but most of the cases in liquidation, if the last 4 years the unit is closed, then PF will not be there. If there is no wages payment, then
CIRP, sir.
No, but in a liquidation, if there is नहीं पहले का तो 24 months नहीं होगा ना, पहले का जो आउटस्टैंडिंग होगा वो 24 months में नहीं आएगा फिर. If the unit is closed.
हाँ, unit is closed. Then वहाँ पे वो भी है ना सर, liquidation.
That if you pay first. No, but you would have, the same person would have filed claim in CIRP also.
Yes.
The same person would have filed claim in CIRP also.
Yes.
So then that period you cannot take as the 24 months. Then you will not be able to take advantage to say that now 24 months it's been in liquidation. Because you had admitted a certain claim in CIRP also as 24 months. But I am not for a moment saying that it is clear, because even we are facing this issue as to how much to verify. So the way RPs are doing in 2 live insolvencies that we are doing, RPs are verifying it with a noting of the claims, that this is the claim you have filed, because that is only in distribution. Aapko verification mein you don't have to verify 24 months. You verify the whole amount, whatever is correct. as per your calculations. You are not going to verify 24 months. That is a calculation that you will have to do at the stage of distribution. How much to distribute?
But
If
today
there is
while
liquidation
verifying,
value.
I have to do the split also. Today while verifying, suppose I get a claim, then I have to, in my say 2 lakhs is for 2 months and 8 lakhs is for earlier period or something. I should do it and record
you
it.
don't
No,
have to do
nothing.
that. No. I would advise don't do that. At the stage of claim verification, why are you getting it to 53? Where is the requirement? The law is saying submitted, verified. The claimant is saying 100 rupees for these many years. These are the sections. This was my salary. These was the salary increase. I was employed on this date. Employment was continuing.
That means and if I am verifying the claim, what is
Yes.
the claim?
Yes.
So up to the date of CIRP, whatever he is claiming,
Yes.
I will verify. And when I will I get into distribution mode, I have to work out for
24 months. Yes.
from date of CIRP.
Yes. That is the place where there is lack of clarity now.
The discretion of RP to put this way to COC or COC? Because what I'm putting a line over here, as a RP, we have to just facilitate it and say, we cannot involve in the distribution. We can only say that
It will be done by steering committee. But if you see, notionally speaking,
nowadays what happens at the time of approval the plan, they decide about distribution.
yes,
They don't leave a steering committee.
yes,
At the
correct.
time of approval, in the same minutes, same meeting, it is decided and voted on that.
But उस meeting में it might not say exact amount in terms of PF and gratuity. If you are doing that, that is great. But we are seeing a lot of
They won't move until unless we do it. COC will not. COC needs it. What is because on that basis only they go for their committee for approval. How much?
no, how much COC members are getting, that is decided, sir. I am saying you are telling me that उसी meeting में they are deciding operational creditors में सबको see in some cases like if liquidation value is 0. Plan itself is saying there are 100 operational creditors, there are 50 of them over 1 crore, 50 of them below 1 crore. For over 1 crore, we will pay 10%. For below 1 crore, we will pay 20%. It's very clear. Then it's all done. You don't have any job. And they will also say entire list of OCs as verified by RP is annexed as so and so. But are you saying your resolution at the time of voting is also saying for workers, I will pay so much wages? If you are doing that practice, then that is great. But that is not the market practice. That the day the plan is being voted, you are also deciding which worker and which employee will get how much money. That I have not seen.
I'm just giving an example just to make it clear. Assuming a plan is of 100%.
Yeah.
Okay. And the secure creditors PM of 1,000 crore.
Correct.
Okay. PF is around 10 crore. Okay. I'm just
Total PF verified.
Total. Now, as per the anklet judgment and all, what we have assumed so far as RP in this, and our responsibility is to get 10 crore to PF in full.
Yes.
Out of plan of 100 crore.
That is the position RPs will
So
take.
now,
Yes.
while I'll write in this, 10 is allocated, 90 remains, which has to be distributed to the COC.
Right.
Are we wrong in this?
No. Sorry, can you repeat that?
So out of 100, 10 will go to
Yes. 90
I'm
remains
not
to
talking
COC.
about
Yeah, you're right.
cost.
CRP cost, whatever is yours. Yes.
सिक्योर क्रेडिटर के लिए 100 है, 100 में से पहले बोलेंगे
Correct.
10 करोड़ आप जो है
Correct.
90 बचेगा.
Correct.
So this is
correct.
This is the clear amount.
Yes, yes.
Assuming if it is not just
But usually that is you're right, absolutely. But this you are saying now because of these judgment which has
Yeah, of
come.
course.
Correct. So
otherwise तो 5 साल का सारा प्लान जो है वो जहाँ भी ऐसा हुआ उसका
never had all these issues. So if you are putting a plan to vote tomorrow, yes, this would be the approach you will do. And same question में ये भी आएगा, sales tax का due है.
हाँ वो भी आएगा. बोलेगा भाई वो तो जीवेट का बोला था, वी का नहीं बोला. जब आएगा तो आंसर भी देख लेंगे.
Correct.
पर पीएफ का तो स्टाफ ने बोल दिया ना बिल्कुल.
Right, absolutely.
उसका क्या करेगा?
Of course. So you will have to presently it is 100% because you will not take as an RP an interpretation.
That's what I'm saying.
And no, neither will the banks.
And bank will not move. The COC will not move until it's just become clear what is done.
What is the amount that is being
That's it. I'm
Thank
asking that it should not become next for the RP to cut it whenever you go to NCLT. Why you are not doing this? And how can you become a discretionary in this thing when we have already order and different.
Right.
So
Right.
how do I? So my question is here: how do I protect myself?
No, your idea to
Second thing is this: sometimes it also happens that somebody comes for default. बोलेगा ठीक है, मैं सर आपको 25% देता हूँ. बाकी पीएफ को मैं 10 साल में दे रहा हूँ.
let me put it this way. you're fair. I mean, put up a resolution for voting is your task. But this information that you're providing and how it is being worked out, this is not a unilateral task of RP. Because ultimately, plan is saying, I will pay liquidation value to all. You have the verified amount. You are just telling COC that if you pay, then I at the time of distribution, this plan can only be implemented if this amount is paid to sales tax, if this amount is paid towards gratuity, if this amount is paid towards if this amount is first paid towards insolvency process. After that will be what is left is something you can lay your hands on. This is what is. That will be basis information. You are not making a distinction. If today, if COC asks you, but why are you paying PF in full? Your answer will be that this is what the law is saying. I mean, if you want to take a different view, you are free to, then don't vote on it. You simply decide your distribution pattern on percentage. Tomorrow at the stage of implementation, if you want to challenge this, you challenge this. That is another way. Why do you have to put numbers? That is what the banks want. But if banks want to put numbers, you will have to put it to the lenders that is there another way you can interpret this? Because today it's not a question as to you are taking an unfavorable position, sir. This is the law. I mean, everybody is affected by it. If Rainbow Papers has said sales tax ko priority milega lenders se, everybody is aggrieved by it. Lenders are not happy about it naturally, but that's the law today.
But just to understand, sir, after किसी का मतलब will be COC okay in case they don't know how much amount they're going to get after approval?
Very difficult.
Very difficult.
We have to put.
You'll have to put the terms.
But I'm telling you that this is.
No, I just want to understand. Usually, it is not a market practice. Is there something
No,
we are not
I am
doing?
saying.
Maybe a big fours are doing. Let's understand that.
And sometimes what happen, even what is the amount to be allocated between secured and unsecured? That how RA does it. RA says I leave it to the COC.
Of course, that
Suppose I am
COC
giving 100 crore now allocation and some 10-20 crore for this rainbow or for
See, issue is
operational cater and all that. Less 80 crore or 90 crore, you distribute and tell me how should I put it. But then some RPs are saying like you put and give.
because
What you are saying, sir, this issue about gratuity and PF, this is not the usual norm. These are hard cases. In working insolvencies, employee dues are either being paid, or if it's not paid, it's only not paid for a portion. It's not that plant चल रहा है, company चल रही है और PF और gratuity आपने बरसों से नहीं दिया है. ऐसा situation common नहीं है. Then अगर PF और gratuity नहीं दिया है, तो then plant is also shut down. It's gone into lockdown, lockout and strike, everything. So this is a strange scenario where you're saying that because of this law that has come, I don't know what to do because there is employee dues. Do I take 24 months or do I submit the whole amount? That is the question you're asking.
yeah.
So that, I mean, definitely. So,
Yes, sir. Yes, sir. How are you? Fine, sir. Fine, sir.
Hello. Vishnu.
No, not for me. Thank you.
So definitely, I would say that you will have to protect yourself if that is the situation in the facts of your case. You will have to say that this is the maximum outflow. If tomorrow at the stage of distribution, if the position of law has changed to some extent, or if there is some clarification that no, for PF you only pay 24 months grid, but gratuity you pay entire amount, or if the Supreme Court says no, this is an insolvent company, how can you be paying 100% PF and gratuity, which is coming up to hundreds of crores, when the secured lenders are not being paid. If that is the interpretation they take, then the resolution that you have voted will not be set in stone. Ultimately, it will be subject to applicable law. So at the stage of distribution, you still have the money, which will go to, because resolution plan will not make this breakup. This breakup is between you and the COC to get their approval. That is the point I'm making. What you will actually distribute will be at the stage when the plan is being implemented, after you have secured all approvals, after NCLT approval, and then when the date is coming for actually the effective date of the plan, when you have finished share acquisition.
The problem for everyone here, it only reaches to that level once you pass through with the COC.
Agreed.
So that is the gateway.
No. So the approach that you are saying, what you are proposing to take, that is the only approach. I would not see any other approach you can take other than putting the maximum liability on the table.
Correct.
That is the only approach. Because the moment you put anything less, You see, ultimately COC has voted on it. It's not like you have voted on it. You have only put the resolution. So tomorrow somebody cannot say that, and you have, which is why I'm saying you have done the calculations basis numbers that are there on the table. Well, claims are verified. Those are all no challenges there. If there is any challenge, you have mentioned it. So I would not.
So in your view, can we take 24 months of fear with the judicial?
No, for CRP or for liquidation?
My view would be that you will have to. There is no other way commercially this law can
No,
work.
more than 24 months is there, then also it has to be done, or only for 24 months it can be done.
No, no, 24 under CRP,
No,
nowhere
even if
that
it is more
24
than-
months breakup is given.
For
Only in liquidation that 24 months
That's
breakup
correct,
is.
sir. But what his question is that liquidation value is what you are paying. So when you are paying liquidation value, do you take it only for 24 months, or do you have to pay the whole
See,
thing?
under CRP claim verification, there is no mention.
Not for verification, sir. If you are paying distribution of, if you are paying liquidation value to operational creditors.
प्रशांत का पॉइंट क्या है सर?
नहीं समझ गया, अभी समझ गया, नहीं अभी समझ गया, लेकिन
अभी सर मेरा एक पॉइंट था रिगार्डिंग मैंडेटरी पेमेंट.
Yes,
As
sir.
an employee, if I am continue employee,
Yes, sir.
my employment, I am still there. My claim whether I will include gratuity or not?
You will, sir. Yes, definitely you will. Because claim, there are two definitions. Like I'll give you a parallel example. Loan diya hai bank mein. Loan has not gone into default
Yes, yes.
when insolvency commencement date arises. Will the bank not file its claim for the entire loan? They will file the claim for the entire loan because they have given 100 rupees of loan. Maybe the repayment schedule is continuing and company suddenly went into insolvency. But there are two things. There is debt. IBC defines two words, debt and debt due and payable. So due and payable is debt which has become due and payable today. But debt is any debt that I have given you. Maybe it is not due and payable today because due and payable is important to determine default. And default has nothing to do with claim filing.
Because in most of cases, the employees are there on the road. So the liability should account for that, what you are saying.
Yes, because
Towards the gratuity.
towards the gratuity, because let us say the plan proposes
Yeah.
termination of
that is
employees.
totally different.
Plan can say,
Yes,
because there are so many
Our
plans where business is being discontinued.
Company is sinking,
So then how will
sinking ship.
your decision of verification
And
of
who,
claims
everybody comes and fight.
should
I
not
want this, I want
affect-
this, I want-
because in the starting I said two things, sir, that I mean, there are a lot of things you need to do as RPs, but two guiding things I would
So
say
you
is
want to say something?
claim verification and information. These two things are most critical because they will always have a bearing on the resolution plan. They are going to take your list of claims as the gospel truth in making their financial projections, and whatever information you put in the information memorandum and data room, they will say this is all we are going by. Even though they may have done some other diligence themselves, they will say humne itna hi dekha hai." So that are two things. If there is any clarification, disclaimers, please be amply clear in putting all disclaimers in your list of claims and also in your information memorandum.
Sir, you want to say?
We too just came to say hello.
Yes, like after a very big event, no.
Yes.
We last week we had a very big event, international event here at Geo Convention. First time in India, I think in 100 years or
118 years.
118
Wow.
years, first time.
Wow.
And people from 110,
123 countries.
23 countries attended.
Wow.
More than
123.
5,000-6,000 physically present here, chartered accountant, and another 3,000-4,000 from,
10,000 was the total strength.
10 or other
6,000
virtually.
physically and 4,000 votes.
7,000 were physically.
7,000.
So like there was a concept called accompanying spouses they have. So there were 600 accompanying spouses who were there for the dinners and the music program in the evening that way.
It was so meticulously planned, everything.
I'm sure if it's so 10,000
He must
people
have worked
planning
for
an
8 to
event
9 months.
yeah, it is.
In last 4 months, so like fully.
Last 4 months fully
We were involved in
dedicated.
that completely. Yeah.
I would say it's as difficult as doing a CIR.
As difficult as?
Doing a CIR.
Yeah, but I think overall it went out well.
Very well, very well. We
And-
enjoyed a lot.
Yeah. And we had like meetings starting from 14th. तो 14th onwards दिन में 5-6 मीटिंग हो रही थी. So like XBRL का meeting है, that was here in 601, 40 people. Then there was a Kappa meeting, so that was on the boardroom. Then there was a PAFA, which is a Pan-African Federation of Accountants, 200 people in the auditorium. That way, multiple meetings are going on. Thank you.
Right.
मैडम का मैसेज आता रहता है ग्रुप पे कि ये वाला मीटिंग उधर था, ये वाला मीटिंग इधर है.
2000 लोग international delegates, and many started coming on 14th.
And some might be still in India only, but they might.
Some might be in India, yes. So abhi जैसे like day before yesterday, one guy from South Chennai, he fell down at Bandra station while catching the train. तो फिर उनको उधर हॉली फैमिली हॉस्पिटल ले गए, एक्सरे निकाला, then the doctor said कि like अभी ऑपरेशन करना पड़ेगा. So then they started calling up from southern region. Then I tried to find out someone, then the auditor, then the accountant, then we reached out to them and said कि like, see, we can go without surgery to Chennai, try. Otherwise, whatever best you can do. But then he got operated. So I think those after effects are also there. मतलब उस आने के पहला ओडिशा से लेके मतलब कन्याकुमारी से लेके कोयम्बतूर हर बंदा फोन कर रहा था कि मेरे को होटल चाहिए, मेरे को ये चाहिए, देन ट्रांसपोर्ट कैसा रहेगा, ओला क्या है, उबर क्या है, मतलब यू हैव टू आंसर so many queries.
First time such a massive organization and multiple things simultaneously going on, one in upper hall, second down, third year. And by lunchtime also, all of a sudden, 5,000 people coming for a lunch. Lunch, snacks, tea, everything. Plus, while going, there is huge traffic jam from BKC to Bandra and from here to Kurla.
I see. Yeah. So many thousands of people. So many thousands of people.
And even finance minister, then this Adani, the Ramdev Baba,
Nigam, Shamak Davar, Anupam Kher, Devendra Fadnavis, like political powers, this what do you say, the entertainment power, like completely.
And all our these study circle meeting were closed for 2.5 months. So everything was concentrated there, the total efforts. So these are first, after I think 25th you opened the, so we started this meeting on 26th. So otherwise 2-3 months there was no meeting.
जितना ज्यादा हो सकता है भी कर लीजिए, but virtually no one has joined क्या इसमें?
14-15 people.
अच्छा, they are okay. Good, chalo. Let us not disturb you much and
Pleasure meeting you.
Yeah, same here, pleasure. We'll take your leave.
Yes.
और मिलते हैं.
These people are helping us left, right, and center. Whatever we want, they're all providing.
That's always important to have a supporting institution. I think that makes a big difference.
Anything we go, yes, done.
मैंने कोई टेंशन ही नहीं. No worries at all. Yes. Okay then. Okay. Yeah, thank you. Thanks a lot. Thank you.
He's also council member. Okay. 5 minutes again.
We would have to stop this hybrid mode. Then people will come out of their company.
But there are many members from outstation also, na, Ahmedabad, Surat. So we cannot say that we provide outstation for see before.
फिजिकली अटेंड करने का मजा ही दूसरा रहता है. फिजिकली अटेंड का मजा ही दूसरा रहता है. पहले जब स्टार्ट हुआ था ये पूरे चेयर भरे रहते, जगह नहीं मिलती. कोविड के बाद ही ये सिस्टम चालू हो गया.
नहीं, अभी मेरे ख्याल से जो नेक्स्ट ब्लॉक चालू होगा सीपी का, उसमें हाइब्रिड का सीपी नहीं मिलेगा और फिजिकल का सीपी मिलेगा.
सीपी के लिए कौन आता है?
एक्चुअली सीपी का कंसेप्ट ठीक है, लेकिन ये सीपी के से ज्यादा नॉलेज शेयर
के लिए आगे बहुत are important because if you don't do that then your AFA will not.
You people.
इतना नहीं है ना अपने को
छोड़ो, आपको काम करने ही नहीं जमेगा. The way the orders are coming, to forget CP. Suppose I give you CP also, but if you don't know the subject, how will you work?
Especially हमारे हर चीज में सपोज जैसे मेरे केस में मैंने कुछ अलग ट्रीट किया है, मंजी ने अलग किया होगा, महेश ने अलग किया होगा, सब अलग अलग सबने अलग अलग ट्रीट किया एक ही चीज को which we are discussing. It might happen.
Right.
Until it is tested at the Supreme Court level or maybe any.
No, there are this issue of now gratuity and provident fund, and the other issue what Navandar was referring to, that liquidation value due to dissenting financial creditor. How do you calculate it when somebody has exclusive security? That's also not clear, because in a lot of cases,
in any contract.
in a lot of cases, it's the structure is such that there is one creditor who has exclusive security, who also has a significant share in the COC. Maybe not veto share, but it's a significant portion because of the lending structure the corporate debtor has undergone. And there will be litigation in such situations.
As far as somebody is having exclusive security and has some, differentiated voting power in this.
Yeah.
So then treatment has to be something different for it, but that has to come from the RA side. But
RAs don't want to get into this, sir.
No, they do get it. Issue comes here when it has the pari passu. Then how do you, see the problem here? I don't want to take a name, but people see that we are distanced person to पहुंच जाएगा. So अपन negative करके अपना पहले करते हैं. वो how do you change that? Because that is a major problem for us.
Right.
Major problem. I have faced
But
in,
that's a commercial issue. How do you propose that the law will deal with that? That's a commercial issue.
Law is legal because what we say कि you have to get upfront.
Yeah, again, that you are saying in a plan where there is deferred payment. That is a situation. Yeah.
Second situation is
Hello.
they are
Yes,
using
sir.
their power only
Yes,
because
sir, there is one issue in case of Rainbow that is specific
Right.
to Gujarat state, and it is not specific to Maharashtra state. Because Maharashtra
That's-
say the identical section to the section 37 of Gujarat is separately, it reads very separately. It reads
Right.
subject to provisions regarding creation of first charge by any central act.
Right.
Whereas Gujarat Act does not read such things. So Maharashtra Act says that first is right to a central act, and in our case we say central act is IBC. So would the provisions be different for if we go by Rainbow in Maharashtra state, or rather we say for different states? Should the different state be read differently through their acts? Because state VAT was state-wise. It was a state act.
Right, sir.
So I have already sent on WhatsApp in the group. We can read on the group itself. Praveen
I
bhai,
will take your query, sir, from Surbhi. I'm not on that WhatsApp, but what I'm saying, sir, is that some time ago we discussed, say that judgment of the Supreme Court in the case of customs, which is in APG shipyard, ABG shipyard, where Sundesh Bhatt versus the CBIDT. What you are saying, it is subject to Central Act. That would be a little bit of a stretch in terms of the Supreme Court's interpretation, because 238 of the IBC, sir, which is the overriding provision, which says that IBC will override other laws. Non-obstante clauses will be specifically referred, like for example in Customs Act, or if you say Karnataka GST Act, for example, I will give you reference of Karnataka GST and even Central GST and Customs Act also. All the charge provision says there will be a first charge, but subject to provisions of IBC very specifically. You are saying it is Central Act, so in the larger ambit of Central
I am
Act,
saying from the MVAT Act, because MVAT Act reads separately the same provision what GVAT Act reads, because Rainbow was in connection to Gujarat VAT Act.
No, I understand what you're saying, but I'm only saying that we will have to examine. It is not a question, maybe exclusive IBC. Let us consider a situation where on the same company's debt, let us say there was central sales tax or say PF dues versus Maharashtra sales tax dues or MVAT dues. You're asking question on MVAT. So we will have to see whether PF will supersede MVAT. If that is the answer, if PF will supersede MVAT because PF is central legislation and MVAT is state legislation, then you have an arguable case that therefore IBC will also supersede.
No, I'm not saying PF who will supersede. I am just saying from the point of the charge where they have said that Gujarat value added tax has a first charge over the asset and therefore they should be considered secured asset. Whereas Maharashtra value added says the central act will have a first charge and then the state act will have a charge. So they say the central act, what central act is? Central act is IBC. So the IBC will have a first charge and therefore provisions of IBC will be applicable. And therefore in 53, they will fall as at level 5, yeah, level 6, whatever the level is for government debts.
Yes, when I meant supersede, I meant supersede in this context, sir. In this context, the argument will be that IBC's charge provision will override the charging provision that is given in MVAT. So that interpretation has been taken by Supreme Court in the context of Customs Act. In Customs Act also there is a charging provision which says that subject to provisions of IBC, customs dues will have a first charge over the assets of the company. But Supreme Court has said because it is subject to provisions of IBC, IBC's charging provision will override whatever Customs Act's charging provision is. So I am saying that it's not a question merely of IBC. You will have to examine in other cases where there is, say, contest between MVAT charge and charge under other central acts which have charging provision, what is the interpretation that the law has taken? In that context, I gave the example of PF. I mean, there might be many examples. There could even be Customs Act, which is taken as an example. So in those cases, has, say, company or say courts taken a view that because that is central act, I will pay that first and then I will pay Maharashtra government under VAT. If that interpretation is there, then you have an argument to make. But since it does not mention IBC specifically, it will be a bit of a legal interpretation. I mean, you will.
But I will not have to go through any other act. I will just go word by word with the Rainbow Act. What Supreme Court has read in Rainbow and what the Maharashtra VAT is stating in its section 30, section 47, 37, the identical section to Gujarat VAT.
Right.
If we read line by line, both the sections putting together, Maharashtra VAT Act is very clear. But who has got the first charge and who has got the second charge? So I don't have to move to any other legislation or any other act for that purpose.
No, sir, you are saying there is a difference between Gujarat and Maharashtra, right? Gujarat does not say.
All the states in,
Yeah,
but Gujarat and Maharashtra particularly is very different. Yes.
So therefore, I am saying Rainbow will not exclusively apply to you. Rainbow is not a case where the section was saying subject to any central act. It did not say that.
Yes, it just said it read Gujarat value added tax. Right. It discussed Gujarat value added tax.
You're right. So therefore, that question as to whether Gujarat VAT will override IBC or not, because IBC is central act, Gujarat is state act, that question was never considered because the section that was being interpreted did not have this language.
What section read Gujarat value added tax is notwithstanding anything contrary contained in any law for the timing in force, any amount payable to any person on account of tax penalty for which is liable to pay to the government shall be first charge on the property.
Right, right.
And so what Maharashtra, what MVAT reads is notwithstanding anything contained in any contract to the contrary, but subject to provision regarding creation of first charge in any central act for the timing in force. So, but subject, it starts with subject to provision of first charge in any central act for the timing in force. Then it says any amount, penalty, interest, or any sum payable by dealer under these acts shall be the first charge of the property of the dealer, as the case may be. So, what MVAT reads is first it will be on the central act, and then it says on the. If we read line by line, we don't have to go to any other legislation. I suppose. You just have to read both the sections together.
So I agree with you, but I am saying since there is today no judgment of the NCLT, NCLAT or Supreme Court that is explaining this question to you as to whether MVAT and IBC which will take priority. There is no judgment. If there was, then that is the answer. I mean, till that is overruled by some other court, you can go by that judgment as an RP. Since there is no judgment, there may be other judgments between MVAT and other central acts, not IBC, but other central acts. So if you see in those cases how the court has interpreted it, you can draw a parallel between that and IBC is what I am saying. Because today you will have to go to a legal opinion, sir. I mean, as RP, what will you do? You cannot answer this question. You will go to a lawyer or to a senior advocate or to a judge or a law firm who will give you a legal opinion. If you come to me for a legal opinion, this is the manner in which that question may be answered, because the law is not saying IBC specifically. It is saying subject to any other central act. IBC is one of the central acts, but there are many central acts which all may deal with, say, charge and first charge or priority of charge. So first task would be to see if IBC there is any clarity. If there is no judgment, you will look at other central acts, maybe some other central acts like custom or PF or any other dues. They are giving some clarity how they will interplay with VAT. We can look at other examples. So if there is an answer, then you can take comfort and say that I have sought this legal opinion. So I have taken this view that MVAT will not take priority over IBC based on this legal view. And on that basis, you proceed. But with the disclaimer that ultimately it is just a legal view that somebody has taken.
Yes.
NCLT will decide, it can go to NCLAT. That issue is there with not just IBC. That is the law of the land. Ultimately, it will only stop at Supreme Court.
But
I would say this is the approach, sir, that you would want to take as an RP.
Fine. Again, the PF also you say then it will be section 11 of the PF Act, which is not amended as per the provisions of IBC. It still gives the priority to various other sections.
Yes, that is right, sir. But I mean, I think there are two issues. One is PF is not amended, you're right. But the second issue is PF covered in that word employee or workman dues? Because workman dues is not a defined term under IBC. Now, workman dues, it is saying should be paid only for 12 and 24 months. When we were just discussing on the same point as to, do you cut off PF for 24 months or do you have to now pay PF for the entire dues? For two reasons. One is you are saying it has a charging provision. That is one aspect. But second aspect is courts are also saying, no, PF is not included in workman dues. PF is anyway independent, not even applying rainbow papers. I mean, that's a separate jurisprudence they are taking. Rainbow papers is another aspect for PF. I agree with you.
Yeah.
So,
fine, sir.
So I think we have about 20 minutes. So maybe we'll quickly cover. I think we have had a very fruitful discussion. I'll touch on some points which maybe are open. This, I think all of you are familiar with, sir, but I'll quickly run through this. What is your role in this whole compliance aspect? Because it's undergone a change since the IBC was enacted. Because IBC under section 30 subsection 3 says RP will present those plans which are compliant with 30 subsection 2 to the COC for voting. That is what it says. Before ArcelorMittal in 2018, before the Supreme Court clarified it, the view that a lot of RPs were taking and COCs were also taking was RP has to decide whether plan is compliant. If you think plan is compliant and you place it before me, I will vote. But Supreme Court in ArcelorMittal said RP does not have such a final role, because the way they viewed it is that it's a 3-layer approach. First, RP will look at it. Your responsibility is to ensure completeness over compliance. First, please see if the plan is complete, meaning there should be something about each of the heads, whether it's insolvency process cost, operational creditors, dissenting financial creditors, whether term is provided, management and supervision, effectiveness. There should be something said on each aspect in the plan. Next aspect is whether what is said is compliant. The second aspect, even if you think something is non-compliant, Supreme Court says, please prepare a report, give your observations, you please put it on record that you feel it is not compliant and leave it to the COC. COC can still vote on a plan that is non-compliant according to you. COC will take your observations into on record and they will vote on it. Because what Supreme Court says is that ultimately it is NCLT. Under section 31, until the plan is approved, it is only a contract between COC and RA. If COC approves it, there is a contract. But if that contract is found to be contrary to applicable law, which the NCLT will decide under section 30 subsection 6 of the IBC, then it's not.
So if the plan is not compliant and RP is supposed to give it to the COC, and then he should give it by way of covering letter, his record or whatever it is.
Right.
Then he should mention it into the minutes also. Yeah, I had given the plan which was such and such, such and such.
Sir, you
Otherwise,
can.
tomorrow what will happen? IBVI will come on the RP.
No, what you do.
He has excess given me a plan. It is not compliant, which according to me. Now you say that I have to give it to the COC. Where should I record my all that? So tomorrow when the IBBI comes for inspection or some court challenges or somebody third party challenge, suppose he gives a plan and tomorrow his plan was in non-compliant and his plan is compliant. So he will go and challenge to the court. Now he has done favor by not accepting his plan.
So what
plan and which plan? So where should I as an RP record my all this?
Right, it's valid question, sir. What Supreme Court says is that in the fitness of things, this is Supreme Court's advice to RP, is that you prepare what they call a due diligence report.
Yes.
And if you see most RP council will today give you something called a compliance report or a limited due diligence report. Say, I will just change the screen for a minute and maybe put that up. So I would say you prepare a document, something like this, with each of the sections and regulations. And you can give your observations against each of the sections and regulations, which is what your council will be doing. And this will also include not just IBC, but RFRP. Your RFRP will have a detailed document. So that document will be fairly exhaustive. It will not be a short observation. And you simply place that on record. In your minutes, you may record that I have given my observations on the compliance of the plan with IBC, applicable law, and with the RFRP requirements. Beyond
this will be part of that document, because otherwise
this will be part. It will be sent to all the COC members.
You see, wherever the non-compliance is there, this communication has to go to RA also.
Of course.
This matter.
RA also, but then tomorrow if we say that stage is over, after that we have to give it to the COC. If COC, we have to give it them with all proper disclosure and all these things.
Yeah, this.
So it should be recorded in the minutes or addendum to the minutes, or
it has to be an RFRP mapping as well as this sheet. This combined both has to go to COC. Then only the plan has to be discussed.
Correct, but then ultimately the COC say approve.
No,
I
sir.
approve his plan.
Sir,
Then it should be recorded in the minutes.
Yes. So you say that post round of compliance report, plan was revised. RPs have submitted now revised plan. Revised plan, you will again check for compliance. You say that I have again checked it for compliance. RP has made some observations on the compliance of the plan, that it is, if there are 4 or 5 in number, you mention it in the report, in the minutes. If you see, and if you have given, if you want to say some highlighting points, for example, it is there in many cases, sir, that some license from say mining lease or something has expired, which is fundamental to the process, which you can't say today is alive. You mention it that this is not there. So the plan is not making a provision on how they will get this approval. So I feel the plan is non-compliant with Regulation 38, which says I will mention what approvals are required. Because tomorrow, if it's not mentioned, IBBI says you have to mention it. So you say it is not compliant. Now it is up to COC.
Now we make it along with the plan. We give our observations to the
Whether to the COC when you send the final
along with the
version.
notice of the meeting.
Yes, absolutely.
But even if the non-compliance is continuing till the time of opening for the voting, you note this thing in the minutes.
Absolutely.
Circulate it better.
That is the fourth point, sir.
Today, as an RP, the main cause of worry is now the IBBI.
Yeah.
Apart from the.
See, but what will happen, the moment you will do is, and the moment it approves, the other guy whose plan is not approved, he will put a complaint to the IBBI.
Yes.
He is under there. Every day it happens.
Every day it is happening, and now the more of a, and according to me, the IBBI inspection is waiting outside the door only. तो खाली दिन 12 तो आ जाएगा.
हमारे केस में तो कोई अभी जाके आता है 6 महीने बाद में हमको प्लान डालना है, अब हमको प्लान डालने दे रहे हो, यू आर 22 साल, अरे भैया जब खत्म हो गया प्रोसेस तो मेरे हाथ में तो आना है.
Right. That was the fourth point, sir, here, that RP to provide compliance report or due diligence report to COC. Resolution plans can be voted on by the COC after considering RP's report on compliance and always observations. Final decision is to be taken by adjudicating authority. So if you
all the plan has to be put for voting, na?
Yes.
simultaneous voting since a while. So as you see, sir, it's like a 3-tier approach the way I look at it. RP will start it, limited due diligence. You will focus on plans are complete in all respects. You then submit it to COC. COC can IBC says COC can approve all plans which are 29A compliant. Their issue is only 29A compliant. COC does not have to see if mandatory conditions are met, but they will also do it. In practice, COC council also looks at it. But even if they feel something is amiss, they can always say that let NCLT decide. And principle of law is that NCLT is the first court, and Supreme Court has also said whatever NCLT has jurisdiction, even NCLAT has jurisdiction, even Supreme Court has the same power. So if NCLT says plan is legal, NCLAT can always say no, I take a different view, and Supreme Court again take a different.
Somebody goes, then only it will.
Of course, if somebody
knows,
if there is no, but I'm saying that if there is no appellant, then great. But realistically speaking, sir, I mean, where are we saying cases which are not even going to NCLAT? I have not seen a case in IPC.
Sir,
which
you are handling on large case, but that is the where it is only the Supreme Court, but otherwise
but
up to 50, 100 crore cases once the NCLT
yes,
approves
yes.
and
then it's finished.
And the money is paid. And sometimes what the COC insists that you pay the money within 50 days, 60 days.
Right.
So once you are paid and we have handed over,
Right.
then if somebody goes and challenges, he will say that I have paid the money, handed over, plan is implemented, and it is all over. Now, where is the question of any litigation?
Right. I mean, this is only in the context of, say, non-compliance.
jet का jet में महीना हो गया उसको चालू करने के लिए employees are saying कि भैया अब मत करो अब हमको पैसा दो
So same if you see Videocon Industries, I think last October, November the plan was approved and January NCLAT has rejected.
Sir, I mean, because see, Supreme Court also, I mean, with all due respect to how they are handling this law, they are also taking different position in different cases, like fundamentally different position. Sometimes they say that law is reading in a particular manner, so my hands are tied, I can't look at it commercially. In EBIX, all RAs went to court saying this was lockdown situation. Company has completely, my plan was submitted pre-lockdown. Company has gone down in the lockdown. Today, I have not even seen the company. There is no material, no diligence. My due diligence is 2 years old. Please allow me to withdraw. Supreme Court said, I agree with everything. They said it's material adverse effect. My resolution plan has material adverse effect. It's a contract. Supreme Court agreed that it's a contract between RA and COC, but said we can't interpret it the way contract law can be interpreted because this is ultimately a statutory process. That's also fine. But then they also said, I can't look at it commercially. If you want me to look at it commercially, you please get the legislature to amend the law. Legislature can amend the law and say there can be provision to withdraw plan. The legislature has not given any provision. I will not let any RA withdraw from the process. This was the practical. They said I will take a legal view, not a commercial view. If they had taken a commercial view, they should have let all those RAs withdraw. Because you look at it, IBC process, the cash is coming from the RA. If you scare the RAs away, there is no money on the table, right? But now in Siva Industries, they took a completely reverse view. Everything was done. Company was going to liquidation. Then they submitted a proposal. Proposal is not a 12-way proposal. It does not meet any of the conditions of 12-way. It was just something called business restructuring plan. But creditors wanted the money. So in that case, Supreme Court said, but because creditors want money, you can't, they can change their mind. In fact, there is a paragraph which is creating problems, which is saying that COC can change its mind after approving a plan also. Then what is left? I mean, so this is the issue with different judges, because judges are humans at the end of the day. So they are taking, in some cases, very legal approach, saying I will only stick to the law. I cannot go beyond act. Act is not saying withdraw, so I can't provide for withdraw. But in some cases, they are saying COC can do anything. So I will allow commercial wisdom.
The problem was that actually the law was enacted to have a process step 1, 2, 3, 4, 5. They were never envisaged all the issues and all.
But वो तो हो भी नहीं सकता है, sir.
But now after 5 years on it started.
Yeah.
That is the problem. If people don't understand judiciary member as a judicial, they only member.
Yeah.
Yes.
This is Rekha. I have a question.
Yeah, please.
You were mentioning that when it comes to resolution plan, the first thing to be seen is the completeness and thereafter the compliance. I'm a bit confused. As an
Your
RP,
voice is
what is,
breaking up a little, ma'am. I'm not able to hear you clearly.
can you hear me now?
Yeah, this is a little better.
Just a minute.
Madam, you're continuing.
Hello, am I audible?
Now you're audible.
Okay. Yeah. So I just wanted to understand, you mentioned that the resolution professional has to see that the plan is complete. That's the first thing, and thereafter the compliance. So
Yes.
exactly, I was reading section 30, subsection 2. It mentions that the resolution professional shall examine each resolution plan received by him to confirm that each resolution plan A, B, C, D, whatever. That
Yes.
itself means is what? Completeness or the compliance?
No, ma'am. I mean, you have to naturally give your observations on compliance. You cannot simply say plan is complete and submit it without your observations on compliance. What I was saying is that the way the law is evolved today is that even if you feel there is a provision which is non-compliant, in your view, you may think that, okay, for example, we had a detailed discussion on dissenting financial creditor payments. You may have a view that if it is not paid upfront, it is non-compliant. That can be your view. And I can tell you that, say, RPs are taking this view because it is the safer view to take in the market when there is doubt. But resolution applicant may say, but this is not the law. The law is that I just have to pay dissenting financial creditor before I pay assenting. So there can be a difference in opinion. So Supreme Court says if you have a difference in opinion, you will still present the plan before the COC for voting. Because you please see section 30, subsection 3, it says RP will place or present those plans which are compliant with 30, subsection 2 before the COC. But that does not mean that if you think a plan is non-compliant, you will not present it to the COC. You will place it with your observations. You please make your detailed observations on why you believe plan is non-compliant, and then it is the COC and RA's decision how to go about it. But in practice, at least say in large consortium COCs, there will rarely be a case where COC will try to overrule opinion of RP on compliance, because everybody wants to only vote on a compliant plan. If there is some major non-compliance, then they will request the RA and RP to sit together and discuss and find a solution on how to make it compliant.
Sir, I remember there is one DC order. I don't remember on which RP it was the order. It was specifically mentioned that since the resolution plan is not compliant, RP is not supposed to put it to the table of the COC.
If that is the case, ma'am, I mean, that order would be, say, contrary to what Supreme Court's position is since 2018. Supreme Court has reiterated that position in a series of decisions. You can see ArcelorMittal, SR Steel, even Swiss Ribbons after that. RP's role is not to decide whether a plan is compliant or not. RP can, even if RP feels that a plan is non-compliant, he is required to place it to COC. Then it is COC's decision if they still want to take a chance and vote on it. I mean, if they feel RP may not be correct, let us see what the NCLT has to say, because NCLT has to decide on its own. NCLT cannot say that because RP has said it's non-compliant, I will not decide. They have to look at it afresh, completely in great detail. But I mean, your role is not in that sense diminished by any stretch, because even before NCLT, it is your application. In your application, as you're aware, now in NCLTs, there is a format in which you have to prepare this application. It will have a detailed table in which every section will be mentioned, every regulation will be mentioned, and which page of the resolution plan has the relevant clause which is showing compliance with that section or regulation. So it's RP's role is very important in showing both COC and NCLT that plan is legal.
Yes, understood. Thank you.
Yeah. So maybe we are almost out of time, but we can, I think we have covered, there was a section on some key amendments recent that I thought we can discuss. Most of it we have covered. We have covered rainbow papers, but two things. One is this asset sale that is now allowed. It's largely untested, I would say. There are some CIRPs, I'm aware, they are trying this now. What it says is that you can sell one or more assets of the corporate debtor to one or more successful SRAs. Important part there is with after providing for manner of dealing with balance assets. That's a key portion here because it is going to come into litigation. It also, there's a regulation 36C also introduced, which says if you want to market assets, then you along with COC, RP with COC will consult and decide a strategy for marketing. If you have to engage any consultants, etc., you can appoint those. There is another section amendment also made under 36B, which also says if in the first RFRP there is no plan received, then you can amend the RFRP to try and do asset sale. So the way it is reading is, it appears as though you must try to sell it as a whole company, but if you are unable to, you can make this option. Some point you have to make this determination as the COC and RP that let us try to sell it individually. If you see real estate companies also, the attempt will first be to sell it as a company. You will not get on first day and say, let us split it into assets and sell it. There are various challenges which are likely to arise. I am also advising on some processes where this issue is likely to come up, where key question is, can you sell the assets of the company and liquidate the corporate debtor? Can you do that? As per this, also, I don't think it is suggesting that, because it is saying manner of dealing with remaining assets. But dealing doesn't mean in liquidation. Can I say, I want asset A and business B? I don't want the company. So put the company to liquidation. I will pay insolvency process costs. I will pay, you divide it proportionally between my asset and the other resolution applicant. But I don't want the company. Nobody wants the company. This will obviously have to be answered by a court. But if you were to ask me, I would say that the scheme of the IBC is not providing for this, because then it is like you are doing liquidation at the stage of resolution, because you're selling assets and liquidating the company. And what will you do with the company in liquidation when you know the assets are already sold? That's a formality, right? The liquidation process is of no use because there are no assets. Even if there will be some miscellaneous insignificant assets. But there may also not be debt, because debt is discharged by selling the two assets. So some clarity is required. I mean, while IVBI and Insolvency Law Committee has given this flexibility, which is good, because there are cases, because what the definition of resolution plan says, it says plan for resolution of insolvency on a going concern basis. It says going concern. That is the definition in the code. There was an amendment to that, which said resolution plan would include demerger and spin-off. So demerger you can do, but when you do demerger, that means company is also surviving. Company is not getting liquidated. It is spinning off one asset, but the other asset is remaining with company. And that also continues.
That amendment was because some company has two steel plant, one in north and one in south.
Correct.
So somebody is taking north, somebody is taking, or two separate business, real estate and another business. So that was plan, that was the purpose.
That was the purpose. So this is, we will maybe see in the next 6 months to a year some clarity, because some large cases, HDIL, all of you are aware of, is trying to do this. Plans have been approved, it's in the papers. But if you see in HDIL, the company is going into liquidation. So this issue is likely to come up soon, because there will be somebody.
HDL something like 4 or 6 are approved on 4 are into not.
So one of the verticals which are liquidated is company, because he's put it in the stock exchange also. Company is going to liquidation.
Only that news was yesterday, I think, the news.
So all the parcels sale in the CRP,
right,
parcel sales, will have the same impact like we get it in a CRP, where all the remaining debt for that project or for the company will extinguish. Will it be like this? Because what we do sometimes, as of now, is for the entire company.
Right.
Once you do the parcel, in the parcel also this will be allowed, or how it will be put up to the in the plan, and how it will go to the NCLT.
So there are multiple ways it is happening. Because there is no process prescribed. In some insolvencies, like if you remember, Umang Realtek was one of the first cases where this project-wise real estate insolvency was allowed. In Umang Realtek, what they said is you make separate COCs because there were no commonalities. They said don't mix. You make separate COC with home buyers only of this project and lenders only of this project. You decide that basis which lender has charge over that asset for the lending. Then that lender will go to that COC. But if you see the case of HDIL, it's a common COC. Everybody has voted on every plan. So it's not a separate COC. So there the debt is common. Distribution is as per asset. So it is all decided by COC in its commercial wisdom.
I'm talking about the extinguishment of the balance, debt, relief, sorts and all this.
It will have to happen. But so that is a question that we'll have to see what happens, because as I was saying that I don't have. Right, but that will have to be decided by COC only.
That's what I'm going into.
Is how do you decide that balance debt is extinguished? Because clean slate principle is attached to the concept that the company as an entity is surviving. So please whitewash the company. Right, not whitewash the assets. You want to whitewash the company. It
has to whitewash the assets. Otherwise, this will not work.
Assets to whitewash ho hi jayenge.
But company also whitewash honi chahiye na. Otherwise, who will?
Liability is never on assets. Liability is on company. Tax dues hoga to company pays.
Assets are mortgaged, so it is liability on the assets.
Fair enough. Assets are mortgaged. That is fine. But assets are mortgaged on all assets. Mortgage, like let's say tax dues. Tax dues they have charged on all assets of the company, right? So your question, there is no answer in the IBC to it. That's what I'm saying. COC we'll have to go through what COC has done in that case.
So time will tell.
Time will tell us, because it could also happen that COC might have said, because there are personal guarantors. Anyway, debt against personal guarantor is not extinguished. But they might have said balance debt will be with company. Company is getting liquidated. So that is gone into liquidation for balance debt. But usme asset to hai nahi to recover the debt. Or because it's a question of also how they want to treat their accounts. Usually,
ultimately it will come on the RP head only whenever this is
but so far at least,
see, you have to advise to see, how you learn the process.
Yeah.
But the end of the process, where can the debt be left? At the end of the CRP, all debt
cannot be. So we have to find the answer later on.
See, ultimately.
क्योंकि जो आरे आएगा वो तो ही बोलेगा भाई मैं ये संग ले रहा हूँ इसके साथ में मेरे को सब जीरो लाइबिलिटी है
बराबर है, लेकिन बाकी जो बचा हुआ है कंपनी में तो
वो कहीं ना कहीं तो बैठेगा,
कहीं ना कहीं तो उसको नॉक डाउन करना ही पड़ेगा ना. लिक्विडेशन में करो कहाँ भी करो, लेकिन अल्टीमेटली तो
एचओ लायबिलिटी ऐसा बहुत सारी कंपनी में हो सकता है जहाँ पे कंपनी इन्वेस्टमेंट कंपनी हो. Investment company will be having an investment in a different SPVs and all these things.
Right.
There, this type of sale will be a big problem because the loan will be sit in the
SPV level, yeah. No, unless there is framework, it's very difficult.
So it's a good idea.
No, I agree with it. See,
you industry will be suddenly,
you have to explore all options. You have to explore all options. I feel this is a capitalist law, because you have reached this problem because of certain kind of lending that has happened. So this will take its course in that fashion, but they will come up with some more clarity. I mean, this cannot be decided by courts alone, because court will not tell you how to do things. Like even group insolvency, till now they have not come out with a framework. It's that judgment of Videocon which is telling you how group insolvency, which is not the way the law should be.
And that judge is Supreme Court now. The judgment is stuck in the Supreme Court. After 1.5 years of the approval of plan, or 1 year, it is stuck. And
but the original judgment is there, sir. I mean, concept of group insolvency is there.
Of that,
but
yeah,
yes, 2019. But I am saying that
August 2019.
The role of judiciary is not to make the law; it is to apply the law. So, some point, Parliament will have to make it. It's a good exercise. Yeah.
Some of these are all commercial laws, na?
Yes.
Where the judiciary sometimes, with due respect,
no, you're right. I mean, it is always like. That's the way it is. Commercial law has to be made by the Parliament, but it will happen. I mean,
sometimes we find that the technical member also, now the technical member is not required, but now some labor division, some division, some.
we are aware of those, sir. Sir, I think mostly we have run out of time now. I mean, I'll quickly touch on the last point I had for discussion, which was on this avoidance transaction item. Now, the plans have to mention how the avoidance transaction will be pursued post approval of plan and how it will be distributed. Distribution, I think we are clear. Even before, RFRP used to say it has to come to COC. Rarely will it say it will go to RA or corporate debtor. In the DHFL judgment also, NCLAT has said it has to go to COC. That is something what is become the standard industry practice at least. It can go. Even now, there is no law which is saying it cannot go. It is only saying plan has to provide.
Plan has to provide.
But
no, the question I have here, just to then we can answer collectively after. See, earlier it was not showing that you share the application to the RA.
Yeah.
See, earlier also in the plan we were mentioning, I think on 19 hours, all the plan you must be having looking if this recovery will go to COC. But now the regulation says that you have to share the application with the RA.
No, because
treatment.
No, precisely for this reason, because regulation has now told that resolution plan will tell you how the avoidance applications will be pursued, not just proceeds will be distributed. Because in the case of Venus, Delhi High Court said, after CIRP is over, avoidance is done, which was a really
it's a no man land. Nobody.
Yeah, no, that's a incorrect view. I mean, with all due respect, because so what they have done is they have taken this from the Chapter 11 proceedings of the US bankruptcy law, where that is a debtor in possession model. Company doesn't lose control of the company, the promoters. But there is a specific provision which says after you've approved the plan, these avoidance proceedings, usually three people will decide. Either one agency will be appointed, who will be a law firm typically, which will be chosen by the COC, or company itself will appoint, corporate debtor will appoint, because their company can go back to promoters. So promoters themselves will appoint, or the trustee, bankruptcy trustee will continue. But trustee will be reappointed in that role to continue it. So they are taken it from there and they have said plan should provide. So let RA decide, because why plan should provide is practically, you're all aware there will be that corpus set up, fund will be set up, because who will pay the fees? Once RP, COC are out of the picture, tomorrow avoidance transaction will go on for 3 years. You will have to appoint lawyer, you might have to appoint senior counsel. You will need a substantial fund. So that fund can only come from the resolution applicant. So court has, the regulations have said, let the RA only decide.
But I have a different interpretation. In my opinion, if the court says that you provide an application to the RA, that means RA can have a both view. It can say simply, whatever proceeds will come, I will give to COC, and out of that it looks like I will leave this thing, and out of this I can give you some proportion to you and some proportion to myself, and I bear all the expenses.
So then the plan, you have the right to reject the plan.
No, I'm saying that the RA, I'm saying we can do that. See, rejection is a different, it's a commercial decision.
Yes.
Reject or approve. But I'm thinking it can be done because earlier there was no provision in such like.
See,
now this provision is there.
Yeah.
I'm just putting some of the where the promoter is not taking by the company.
Right.
Some transfers where somebody is having a good what you call control on the law and all this thing, regulations, I would say, understand the law forms and all this thing. Then they can take this. The recovery can come maybe in 2, 3 or 4 years.
Right.
So somebody is like, okay, I'll pay you X amount of that. It's like zero or something which was paid for DHF or something like that. Avoidable was transferred to this.
1 rupee.
Here, right?
Yeah.
Now the regulations, earlier it was not there. So if regulation says that, then RA can put a value to that. Out of 100, immediately I'll pay you.
You can. So point was, there is no bar, but I would say that the judgment in DHFL is naturally a guiding principle. It is the judgment of the appellate authority, where see regulation was not there, but there also creditors decided in their commercial wisdom that let the money go to Piramal. But one creditor had a problem with it, and that creditor said, I am approving the plan, but I am not okay with this. This money should come to us because it ultimately our money which has been siphoned out and taken out, etc. Piramal's.
So if they approve, of course, everything goes with the approval.
If they, but there they approved, but they approved, and the NCLAT said, no, you can't give it to RA. You have to bring it back into company.
So then this regulation is not correct.
But regulation is not saying anything contrary. They have been very careful because
treatment likha hai,
treatment likha hai. Plan will provide treatment. It can be anything. But question is, tomorrow what you're saying is that tomorrow if plan says it will go to RA and COC approves.
So I may have a distribution out of that also, or I may give some upfront to them.
Right.
Out of 100 rupees, I am paying you this for 2 rupees.
No, I agree.
Along with all the money what I'm paying.
I'm saying that
Is it a non-compliance if somebody puts that?
it's not a non-compliance, but again, whatever law is laid down by NCLAT is applicable law. So under 30 subsection 2E, the judgment of the NCLAT in DHFL is the law of the land. So if you propose a plan that, okay, 20% of avoidance transactions will come to me, 80% will go to COC, that is in compliance with this regulation, which says you have to say where the money will go. But it can still be in non-compliance with the DHFL judgment.
But that regulation comes later after that.
But the regulation is not contrary to that. That's what I'm trying to tell you. The regulation is only, it's a procedural regulation. पहले क्या था? Avoidance transaction के बारे में resolution plan would be silent unless your RFRP says you must say, right? So because RFRP is saying, please tell us what you will do with avoidance money, they would put it. Now, instead of it being left to RFRP as a requirement, IBBI regulation is saying you please mention it.
But they are saying share the application. That is where my concern.
No, share the application is only because they have to tell you now how to deal with it. They have to tell you two things. That is just a procedural thing. I mean, what is the concern about sharing the application with the RA?
Otherwise, see, if I'm RA and I have to just write it that this will go to COC, then I am concerned about the application, whatever it is, whether it's 1,000 crore.
But it's the learning has come because of cases like DHFL. In DHFL, the asset is the loan book. There is no other asset, right? It's a financial services company. So the point is, today, like there is one more matter. I will not mention the company.
There can be value of this, which can be decided in the in the consensus with the COC and the RA. That's what I'm trying to put.
It can be. I agree with you. But unfortunately, if NCLAT's view is upheld by the Supreme Court, and Supreme Court says you must give it back to the company. It must be cash flow in the company, or if Supreme Court says it must go to COC, two things they can say. Then this regulation will not be contrary to that. That's what
it will go to again to the new promoter.
Correct. So
then it will be moved in the circle only now.
It's always come to the company.
Come back into company.
If it is only to the company, written by company, then it will go to Piramal. And if it goes to the COC, then only the.
So that clause is saying in the RP, the clause that once it's reaching a cooperator, it has to be distributed to COC.
Yeah.
In the manner what is deciding in the distribution manner.
So I'm only saying is that this regulation is not deciding to whom the money will go. Regulation is giving that discretion to. It is not even giving discretion to RA.
I can put in a plan. That's what I'm just thinking.
What I'm trying to tell you is that the regulation is not giving discretion to RA to decide where the money will go.
That is the interpretation.
No. You suggest the treatment. You propose the distribution. But it is not his decision ultimately. Ultimately, decision of COC and has to be approved by NCLT. If NCLT feels that because of a judgment of the Supreme Court or NCLAT that this distribution is incorrect, they can strike it down. So that's the point I'm trying to make. So ultimately,
it will not be non-compliance as RP.
Yes. You only have to see whether plan is saying.
If it was not there.
Yeah. So at the RP and COC level, you will never be able to 100% decide if something is in compliance
I
or
would try to put this way, it can be maximized value. If something like this, something about DHFL, like one of the example, but somewhere also real estate value you find many things.
Yes.
There could be much value which was sitting there, not in the books. There can be also.
Of course, lot of.
And nobody will put up money until unless.
Yes. We are seeing so many cases like even radius developers. One company will go, but others are all. There is no asset value.
I understand this that it can be given a treatment, but of course, what you said, I understand that.
Yeah.
We'll see in case anything comes like this or NCLT.
Hopefully, there will be clarity soon.
Yeah.
So with that, shall we end, sir?
Yes.
Can I ask one question before we end?
Please.
I refer to the amended section 36B6A. It says that if the resolution plan is not received, the RFRP can be amended and the sale of one or more of the assets of the corporate debtor can be done. I'm just putting up a practical case wherein the company is a very large assignment, but the company do not have any assets.
Right.
So thereby there was no valuation was done because there is actually no assets. However, the company does have huge business losses, and that is the assessed losses. The RBI has rolled out Form T. There are a lot of expression of interest also has come in, and there are certain parties who are interested to submit their resolution plan. By any chance, assuming that there is no resolution plan finally comes, so in that scenario, whether that business losses will be considered as an asset, and thereby there will be a amendment in the resolution, RFRP, for sale of one of the more assets of the corporate debtor, and that RP has to put this particular agenda item to the COC for their approval.
Yes. So, I mean, this has also been tried in Aircel. If you see the resolution plan that was approved by NCLT Mumbai, it's an asset monetization plan. One of the key assets that were being transferred or sold in the market was the losses of the company that was being sought to be sold by the RA to monetize money, and that would be used to pay the lenders. They were trying to sell some fixed assets also like towers and spectrum, etc. But large portion was the losses that Aircel as an entity had suffered. That plan is stayed by NCLAT, but not stayed on this point. It is stayed on the point of telecom dues, which is in Supreme Court and NCLAT. But so far, at least, I also fundamentally don't see an issue with this because it's an asset from accounting perspective. Also, it's an asset that can definitely be done. And I'm just giving you example of Aircel where you can examine, say how this has been done. I mean, that's a document in the public domain because plan was approved by NCLT Mumbai. So you can look at that also, ma'am, and see in practice how it is done. But I can tell you this is tried and tested. It has not been implemented for other reasons, but yes, I don't see an issue with this. Whether you are doing it under 36B or not, 36B is giving you option of just selling that asset. If nobody wants to take entity with the losses, you can try that. But again, it will be subject to our larger discussion as to what you will do with the company. Will you send it into liquidation? Is that
no,
permissible?
then in that case, we'll immediately file for resolution because there are certain judgments available.
Yeah, so that has to be seen whether in CIRP you can send to liquidation, but otherwise even in liquidation you can attempt. I mean, the losses are not going to deteriorate any further. So
yes. Yeah. Thank you so much.
Losses will not be allowed to company if the continued, no?
No, I mean, so you can always, you have taken the company in CIRP, sir, but you can always monetize the losses. The losses also can be transferred to some other company.
No, losses by itself or
with the company.
With the
company, with a merger. You are RA, you take the company through an SPV.
Section 79 of income tax will say if it is a private limited, only listed company that losses will be allowed.
Right, that is subject to applicable law, that restriction.
My company which is losses,
right.
I cannot sell it to you and you enjoy the loss. There is section 79 where the change of shareholding is beyond 50%. It is not allowed.
But section 79 has an exception to IBC.
But then for first plan only. First plan.
Oh, for resolution, not for subsequent.
Then I cannot take it to.
Sir, the way it was done in Excel is the plan itself was saying that I will sell it.
That I think income tax may agree or not agree.
Yeah.
वो प्लान में रिलीफ मांगता है कि वो इनकम टैक्स में
हाँ बट रिलीफ मांगते हैं लेकिन कैरी फॉरवर्ड विल बी
एक ही जगह मतलब
इट कैन नॉट सब्सिक्वेंट समझे आपसे कमी मैंने ले ली मैं विष्णु को बेचूंगा तो विष्णु कैन नॉट
प्लान में ट्रीटमेंट किया क्लियर हो
Yeah, because they tried to do it as part of plan, so they took that interpretation that even the subsequent sale will be.
I don't think
so.
Sir, that will be difficult.
That will
be stretching it too far.
Compliance करना पड़ेगा.
No, sir, and their
79
see,
is the
sir,
change.
Aircel was a listed company. Aircel was also a listed entity.
72A. So 72A.
72 में वो merger amalgamation and that business continuity and all lot of
shareholding वाला
and all asset to continue.
But it will largely covered by 72A क्योंकि merger वगैरह वहाँ पे है.
Right. Sir, with that, thank you for the opportunity.
Thanks a lot.
I'm sorry I have to end it, but I have a call at 5:30, which is fixed. That was the only reason.
We thank you.
Thank you a lot. It was a great learning experience both ways, I think.
So, it was a really, very interactive as well.
Yeah. No, that is, I mean,
We discuss a lot, which was not there in the presentation, but it's good to know about your, knowledge on all the subjects.
Thank you.
I believe it will be a good interaction, which will be useful for us as well as the people who want to learn.
yes, definitely, most
And
happy.
also a point which we have opened up, might
Yeah.
be, we'll see that it will soon.
No, which is why, I mean, knowing the audience, my presentation had only 5-6 slides. So there is nothing in the slide which will help you.
Thank you very much.
Thanks a lot. And actually, we are here all RPs only.
Yes, yes,
This
of
study
course.
group only RPs and
Of course.
others are.
Yes, sure, I will share my presentation. I'll send it to sir and he can pass it on. Definitely, definitely.
Sure. Thanks a lot.
Yeah, thank
Hey,
you.
recording stopping. I'll share.
Yes, yes,
I
sure.
share my number and WhatsApp.
Sure. Mr. Prashant. Okay,
So the Khitan which is there at the Nagin Point, Khitan.
Legal associates is different. This is Khaitan and Company.
But earlier one partner was there, Anu or something was there, no? Who left the Khitan and company.
Possibly, sir. We have 1,000+ lawyers and 200 partners today. So
Yeah.
200 partners.